Now, please you mention. I have to mention item number 17.
17.
17.
Yes.
We tried to contact the other side, but we were not able to contact. At the same time, the learned English Council having some difficulty could not appear today. So let us be adjourned for today and 2 weeks time will be made.
Read order 9 rule 4. It is applicable only if suit is dismissed under order 2, rule 2 or rule 3.
Yes, Lord.
Now, what is your submission?
Lordship, my submission is that, Lordship, as Lordship
Read the impugn order.
in order, Lordship. Page relevant portions, Lordship, page 49. Last paragraph, Lordship. The petition is like a mercy petition filed in a court of law, and the petition in every day's delay by the giving sufficient reasons is not explained. Day-to-day, Lordship, is not explained. And the next, Lordship, next page is, Lordship, just mentioning that due to his illness and fact and circumstance mentions above, he could not file the petitions for years together, and later on stating that for the same, he could not file the petitions for 634 days.
Okay.
It's not reason.
Heard Mr. I. Hawk, learned counsel for the petitioners. This application the prayer for restoration of MAC case number 2235/2013 was rejected by the trial court on the ground that the delay on the ground that the delay
Not explained.
in approaching the court for seeking restoration of the aforesaid case has not been properly explained. The facts relevant for consideration of the instant revision petition are that the petitioner preferred a petitioner who filed the case.
Lordship, here, Lordship filed the case by the petitioner's wife. He died, Lordship. So subsequently, he a restoration petition along with a substitution petition was filed.
That the
Lordship, page 13, Lordship, claim petition.
petitioner's wife who approached before the court for restoration.
Husband, Lordship, present petition.
What was your locus standi?
Lordship, he filed also substitution petitions, as because his wife already died, Lordship.
That substitution petition was not
Not,
considered
not,
because,
Yes,
because
sir.
of
yes,
non-restoration.
yes.
The petitioner's wife had filed a MSC case under motor accident claims case under section 166 of the MV Act, 1988, seeking compensation for death of the son of the petitioner who died in an accident, in a vehicular accident. The said case was registered as MSC case number 2235/2013 and has been pending in the court of learned additional district judge number 2, Kamrup Metro. Next para. It is submitted by learned counsel for the petitioner that the petitioner, the respondent number 1 insurance company, appeared in the said case and contested the claim case by filing written statement. However, the other respondent who did not appear as notices were not duly served on them. Learned counsel for the petitioner submits that on 23/6/2017, 7/8/2017, 15/9/2017, as well as 14/11/2017, none of the parties appeared before the learned motor accident claims tribunal. Hence, by order dated 14/11/2017, the learned tribunal was pleased to file the case till the appearance of the claimant. It is submitted by learned counsel for the petitioner that thereafter in the year, why there was such a delay?
Lordship, here in his petitions is stated, petitioner has stated that he was not aware about this status of the case. And he was, Lordship, in this condemnation petition, he was stated that he was till searching this advocate, but still he is not.
Learned counsel for the petitioner has submitted that there was a communication gap between the petitioner and the engaged counsel of the petitioner, and therefore the petitioner was not aware about the status of the case. More specifically, he was not aware that his case was filed by the court, by the tribunal, by order dated 14/11/2017. And therefore, on 9/9/2019, he filed an application. When your wife died,
Wife is died.
in the meanwhile, the wife of the petitioner, who is the claimant in MSC case number 2235/2013 died, and therefore the petitioner approached the Court of Learned Additional District Judge cum member Motor Accident Claims Tribunal for restoration of the MSC case number 2235/2013 by filing an application under Order 9 Rule 4 along with an application for substitution of the claimant by the present petitioner. However, by the impugn order dated 3/3/2022, the Court of Learned Additional District Judge number 2 Kamrup Metro had rejected the prayer for restoration on the ground that the petitioner has approached the court after a long delay and has not been able to explain the delay sufficiently. Stop. I have considered the submissions made by learned counsel for the petitioner as well as peruse the materials on record, including the documents annexed along with the revision petition. It is very strange as to why an application under Order 9 Rule 4 of the CPC was filed in the first instance when the MSC case number 2235/2013 was not dismissed at all, but it was only filed till the appearance of the claimant as apparent from the as it is apparent on perusal of the order dated 14/11/2017. The question of delay in filing the restoration petition in this case does not arise as the case was never dismissed and it was only filed till the appearance of the claimant, and it was incumbent on the court, that is the Court of Additional District Judge number 2 Kamrup Metro, to restore the MSC case number 2235/2013 as soon as the petitioner appeared before it and filed a substitution petition narrating about the death of the original claimant. As there is no bar of limitation in case of a case being filed, in case of an MSC case being filed, the question of condonation of delay in restoration does not arise at all. Hence, stop. For the reasons mentioned above, this court is of considered opinion that the impugned order is not in accordance with law and liable to be set aside. Accordingly, for reasons mentioned herein above, the impugned order is hereby set aside. The Court of Learned Additional District Judge Number 2, Kamrup Metro, Guwahati is hereby directed to restore the MSC case number 2235/2013 and consider the application for substitution if to and allow the petitioner to file the application for substitution of the claimant and consider the same in accordance with law. With above observation, this revision petition is hereby disposed of.
Lordship, one more prayer, Lordship. Lordship, since this case is long pending, so one directions may be given, please speedy trial within a time bound. And
First, let the case be restored.
Lordship, and another thing, Lordship, here, Lordship, the respondent is foreign country, belongs to foreign. So-
Everything will be taken care by during the inquiry by the tribunal. If you have anything to say, submit before the tribunal. Nothing more before this court.
Hello.
Time being,
Item 5.
Yeah.
Item 3 and 5.
Five, charge sheet, मतलब scan copy not received, my lord.
item number 5,
Scan copy not yet received, my lord.
heard Mr.
Yeah, madam.
A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. It appears from the office note dated 27/2024 that the scanned copy of the trial court record which was called for has not been received. Registry to issue reminder for the same. Let this case be listed again on
Registry.
37.
मतलब in
Before that, I take indulgence of this honorable court, my lord. My case was dismissed for default, my lord, by your lordships on 17, my lord. Then some name has been wrongly shown, my lord. That is why I could not appear. And IA was filed, my lord, accordingly. On the very next day, IA was filed, my lord. And my lord, early in the morning, my junior mentioned before lordships, but he could not say anything regarding dismissed for default by this honorable court.
No, it has
So-
to be mentioned before the senior court taking the same roster. It is not necessary that the court which dismissed the case on default should take up the IA. It will go as per roster.
But I
before
thought that since lordship dismissed for default.
No,
so
that is
pass
no,
the order.
no such rule is there.
So
you
you
have to
specially, lordship will take up the matter.
I'll not take up. I'll take up only if it come in the cause list.
Yes. Sir. Extreme, sir.
May it please, Lord. Lordship, this is the second bail application. And the High Court's direction was not complied by the learned trial court. That's why I approached with the second application.
No,
I have been engaged in jail for 724 days till today. And the trial is not completed yet.
in this case, my lord, flag B, my lord. All the 5 witnesses already examined. My lord, may kindly go through the flag D, my lord, registry note, my lord. All 5 witnesses examined, but on the day, learned APP, court below, my lord, he has asked for to before the court applications, some document, my lord.
No, at what stage the case is pending now?
Still in the evidence stage, Lordship.
No, or if all the five witnesses have,
Examine, my lord, but regarding my lord, see what is statement, my lord, flag D, my lord, kindly go through, my lord, flag D,
flag B,
D, my lord,
D.
D, my lord. Next page is the report. No, document, we shall say. Let me prayed for bringing some documents.
16:7. What happened on 16:7?
16/7,
This case was fixed for hearing.
yes,
Mm,
16/7 was fixed for court witness, actually. The
What happened on that day?
court is not examined. Then next date is given 30th of July this month.
We are fixing it after 30 July.
Yes, that will be better, my lord.
You,
Otherwise, my lord,
because the evidence is complete.
complete, my lord.
Argument will come.
No argument for one day only.
Or should I dismiss it with an instruction that to expedite the disposal? Or you may wait.
Okay, I will do.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. On perusal of the status report received from the Court of Learned Special Judge NDPS Karbi Anglong, it appears that the case was last fixed on 16/7/2024 for examination of court witness. And what happened on that day, status report is silent about that. However, learned counsel for the petitioner submits that on 16/7/2024, no witness was examined and next date is fixed on 30 July
30th.
2024. Learned counsel for the petitioner is requested to inform about the status as to what will status as on 30 July 2024 to this court on the next date fixed. Let this case be listed again on 2nd of
August.
not after some more days. 2nd of August. For hearing.
Okay.
May please, your lordship. Lordship, in this case, last occasion, lordship wanted to see the supplementary charge sheet of the final complaint of the,
To Shraddha.
in this case, lordship. That is, I have flag mark, lordship. Regarding the involvement of the present petitioners.
Supplementary charge sheet,
Yes, lordship.
where in the scan copy or in the case?
Scan copy, lordship. It is along with the scan copy. It was on last occasion, but we could not find out because of this. It's inside the record, lordship. But I informed the court on that day.
What is there?
There is nothing against the petitioner, lordship.
No. This 395.5 kgs of ganja
Recovered from
was
one Srivas Das,
Sribash and Papu Chatterjee.
lordship. Not from Papu Chatterjee also. It's from Srivas Das. He was driving the vehicle, lordship. He was intercepted and thereafter he was arrested in this case. Subsequently, he was released on bail on medical ground, and to our information, the person expired after this, after the bail. Then thereafter what happened, the case is split up, Lordship, and
No, on last occasion, there was a query. A submission was made at bar that the only material against the Kajal Devnath is
Is the-
the statement of the co-accused.
yes,
My query was, what other material is there on record?
there is nothing, Lordship.
Supplement complaint is there. So I have also not gone through that supplement complaint. Possible, I read out. One witness. Because in main complaint, Lordship, page 43. Page 43, paragraph 63.
Who else has been granted bail in this case?
One
Yes.
Papu Chatterjee, Lordship.
Papu Chatterjee. He's the owner of the vehicle, Lordship. His driving license also found inside the vehicle at the time of interception.
Okay.
And one more got anticipatory bail, Lordship. That is Achilles Pandit. Is the owner of the vehicle.
They are facing trial.
They are facing trial. They are appearing in each and every date.
So your main ground is one ground is prolonged incarceration,
Yes, Lordship. They're inside, he is inside 2 years, 6 days,
6 months.
6 months, 34 days. No? 34 days.
More than 2 years, 7 months.
Yes.
That is one ground. Another ground is that
Another ground is on the basis of the co-accused statement, Lordship.
apart from statement of the co-accused, nothing else is there.
Nothing else. And co-accused also mentioned this.
Regarding this involvement of the accused,
Other cases also it is written there. Lordship, may come to page 7, 8 and
Same way.
paragraph 7, 8 and 9
where?
in the supplement complaint.
I have mentioned that thing, or in that case, Lordship granted bail, Lordship.
No, in other case, we are not concerned.
Because this is material. Lordship, PAP accused.
No, let us first find out what material is against.
Lordship, may come, go through, please go through paragraph 7, 8 and 9. Supplement complaint.
Yes.
7, 8 and 9. Materials are there in paragraph 9, Lord.
No, that I have to understand. In the complaint, this is the accusation.
Yes, Lordship. It will be
This-
during the trial. Lordship.
No, I am not on that. This accusation must be on the basis of some materials.
It is there, Lordship. Case numbers are written there, Lordship. Paul
You
details,
first understand my question, then reply it.
Lordship.
When you file when you accuse a person, it may be on suspicion,
Obviously.
it may be on credible information, or it may be on the basis of evidence collected during investigation.
Yes, Lord.
The submission of the counsel for the petitioner is no evidence is against the petitioner except the statement of the
the
co-accused, which is inadmissible in evidence in
Yes.
view of Tufan Singh's case.
Correct, Lordship.
Therefore, my query was, what material is there except the statement of the co-accused?
Paragraph 9.
Yes. Read out.
Lordship, copy is not with me, Lordship.
Now, paragraph 9 says that he is the supplier of 359 kgs of ganja.
This is the statement.
What is the basis of this accusation?
That person is not available, Lordship. right
Lordship, may please to see, may I read, Lordship? I got-
You can take this.
I got the copy, Lordship.
Yes.
It is available in my mobile. Kajal Devnath is the supplier of the said 359.5 kgs of ganja. And both the arrested accused Sribas Das and Papu Chatterjee admitted that their voluntary statement that Kajal Devnath is loaded the seized ganja in Brahmpura Jungle, Tripura. Kajal, that is
So,
Kajal Devnath.
so let me understand. So the basis of this accusation that he is the supplier
Lordship.
is the statement of Sribash and
Papu Chatterjee.
Papu Chatterjee,
Yes, Lordship.
which she is objecting.
Lordship, Lordship,
What else is there?
Lordship, below, I may be allowed to read. Lordship.
Yes, yes, please.
CDR analysis also revealed that there are numbers of phone calls between Srivas Das and Kajal Devnath before and after loading the ganja and intervening night of the loading. This is the materials. Then CDR analysis also clarified that the involvement and relation of Kajal Devnath with another arrested accused, Govind Saha. Then lots of mobile numbers and the call details are given. Then Kajal Devnath is also wanted in NCB crime number 16 of 2019 and NCB crime number 18 of 2018. Case details of NCB crime 16 2019, NDPS case number 32 of 2020. Recovery and seizure of 243 kg of ganja from possession of Sandeep, son of Fateh and Suraj Singh.
My lord, this is not regarding.
Lordship, let me
let-
complete.
Motive is there,
No,
that is another case.
let him come.
Oh, Lordship, why my landed friend is objecting when I have
Let him-
submitted?
let
I
him-
may be wrong. My
Let him,
submission may be
yes, please continue.
case details of NCB crime number 16. This is another case.
এখানে তো mobile number.
NCB case number so and so. Recovery and seizure of 243 kgs of ganja from possession of Sandeep, son of Fateh Singh and Suraj Singh, son of so and so. Truck number so and so. Near Raju Dhaba supermarket, Beltala, Guwahati on 21/10/2019. As per investigation report, Kajal Devnath was the supplier of the above mentioned seized ganja and he supplied the seized ganja to Sandeep and further delivery to Govind Shah. The case is listed at Honorable Session Judge Kamrup Guwahati, case number 16 of 2019. Then another case, NCB crime number 18 of 2021, NDPS case number 4 of 21. On 25/7/2021, NCB Guwahati seized 360 kg of ganja from a truck bearing registration number so and so near Narayana Super Specialty Hospital, NS 37 Amingaon. Ganja seized in the instant case was recovered from conscious position of merchants, namely Sanjay Kumar Saha and Javed Iqbal, who were arrested on 25/7/2021. On dated 17/1/2022, complaint in the case was filed against Sanjay Kumar Sharma, Javed Iqbal and Kajal Devnath at Honorable Judge Kamrup Rural, Amingaon, so and so. That in this voluntary statement, Kajal Devnath admitted that he is frequent change his mobile number due to fear of apprehension. He also admitted that he used mobile number so and so in 2019-20 and switch off the number after arrest of Sri Srivastava. CDR analysis proved that the communications of Kajal Devnath with other arrested accused and receiver Govind Shah with the two numbers. Presently, Kajal Devnath is using one number which is fake and registered with other name. Then paragraph 11, the Kajal Devnath also admitted that he is engaged in business of illegal ganja from last 5 to 6 years. He handed over seized 359 kg of ganja to Srivas Das and Papu Chatterjee to send this ganja to Govind Shah at Bihar. He also identified the photo of Srivas Das and Govind Shah and mentioned the name of other persons together whom he done the illegal business of ganja. That from the all circumstances and evidence, it is proved that the Kajal Devnath is directly involved in illegal business of ganja and handed over the seized 359.0 kg of ganja instant to the Sri Srivastava and Papu Chatterjee for further supply. It to Govind Saha. Mobile communications of Kajal Devnath with other accused persons during the intervening night of loading and transporting of the seized ganja corroborates the statement of all arrested accused and Kajal Devnath. These are the materials collected during the investigation and they were placed before the court. And on being fined the prima facie materials, court has named the charts and trial is going on.
My lord,
What wills we can produce before before evidence is laid?
my lord, what my learned friend read, that is pending before the district judge, another case, and your lordship has granted the main accused bail in this case, lord, in that case, lordship. And that is also pending since about 3 or 4 years back, lordship. That record is right now not with me. And the allegation against the present petitioner as per the main final complaint, lordship, kindly see at page number 43, paragraph number 63. My lord, here mentioned, lordship got it,
Yes.
that Kajal is the main supplier of so and so, that both the arrested accused Sribas Das and Pappu Society admitted this in their voluntary statement of Kajal loaded the ganja in Baramura jungle, Tripura. Kajal told Pappu Chatterjee to carry the seized ganja.
What is your submission regarding CDR analysis?
CDR is this lordship, this is the CDR in the record. The number what they have furnished, it is in the record. That is not in my name. That is your lordship. And they have right now in their supplementary complaint, they have stated Kajal Devnath. But earlier it was Kajal. No addresses at all. And the person, the Sribas Das, after arrest, through Sribas Das, he was not identified, lordship. This the person who handed over all these things, has loaded the truck. That person is not available right now before the court. He expired, lordship. And also Sribas Das, Pappu Chatterjee was there. Through Pappu Chatterjee also not identified the person, lordship. After arrest, his address, his name, everything has given in the final complaint, lordship. And he's facing the trial since about 2 years, 6 months, lordship, 7 months. And lordship, as per the latest judgment of the apex court, if there any case based on the statement, then there is a direction to release the person, lordship. Paragraph number 13. As per legal aid, Supreme Court Legal Aid Committee, which was decided in the year 1994, lordship. We have discussed earlier also in this regard. Supreme Court Legal Aid Committee has it is set to the following. Lordship, paragraph number 13, after all discussion, lordship, coming to the facts of the case, bail has been granted to the appellant firstly on the ground that the appellant has been
Which para you are reading?
13, lordship.
Yes.
Coming to the facts of the case, bail has been granted to the appellant firstly on the ground that the appellant has been implicated based on statement recorded under section 67 NDPS Act, and that such statements are entirely inadmissible in view of the decision of this court, Tufan Singh versus so bail has been granted on merits as well. And secondly, the bail has also been granted relying upon what is held paragraph number 15 of the decision of the Supreme Court Legal Aid Committee, as the bail was granted on merits by relying upon the decision of the Tufan Singh. There is no reason for High Court to have imposed all onerous conditions incorporated paragraph 15 of the decision of Supreme Court Legal Aid Committee. So Supreme Court Legal Aid, I have only one copy, lordship, regarding Supreme Court Legal Aid Committee case. I'm supplying that, lordship. Herein,
What is there in para 15 of?
para 15 is there, lordship. Para 15, may I read?
Yes, please read.
But the main reasons which motivated the Supreme Court Legal Aid Society to file this petition under Article 32 of the Constitution was the delay in disposal of the cases under the Act involving foreigners. The reliefs claim including a direction to treat further the detention of foreigners who were languishing in jail as under trials under the Act for a period exceeding 2 years. As void or in any case, they be released on bail, and it was further submitted by counsel that their cases be given priority over others. When the petition came up for admission, it was pointed out to counsel that such an invidious distinction between similarly situated undertakers who are citizens of this country and who are foreigners may not be permissible under Constitution, and if priority is accorded to the cases of foreigners, it may have the effect of the foreigners being permitted to jump the queue and slide down cases of citizens, even if their cases are old and pending since long. Council immediately realized that such a distinction, if drawn, would result in cases of Indian citizens being further delayed at the behest of foreigners, a procedure which may not be consistent with law. He therefore rightly sought permission to amend the cause title and prayer clauses of the petition, which was permitted.
No,
In
in this case,
Lordship, it legal.
no, in Frank Vita's case,
in
this case which you are relying, this is on a slightly different subject.
Lordship,
that
there is
Onerous condition were imposed.
this one, new
Yes, 2000 new case.
one, Lordship.
New
On the
case.
basis of Tufan Singh judgment and this.
Now you are relying mainly on Tufan Singh and
24,
long incarceration.
long incarceration and the statement under 67, Lordship,
Tufan Singh.
Tufan Singh.
These two you are relying in your
Yes.
case.
Yes,
Okay. Any sir?
long incarceration, we have mentioned our submission, which is mentioned in the order sheet. I annex with my petition, Lordship.
And relying on the recent judgment of Supreme Court, it's paragraph 5, 6, 7, and 8, 9.
And the PS na ki hedu. Na bahira role. Whether it is related to NDPS or something else, Lordship.
Paragraph 5,
Vera?
paragraph 6, 7, and 8. Judgment dated on 16 July 2024.
What it says?
Now, let's say below I want to read. Paragraph.
No. Without reading, you can tell the gist.
The basis of section, in case of commercial quantity.
37 cannot be over.
Yes, it cannot be.
That is the,
Yeah, this is the. In this case, Lordship, the accused was granted bail by the Meghalaya High Court on the ground of because she was suffering from HIV.
okay.
Then state of Meghalaya filed SLP, then this judgment was passed.
Okay, but their case is different. They are on 67 and prolonged incarceration.
Lordship, in my humble submission, there cannot be, this ground cannot be a ground.
Your submission is under no circumstance 37 can be
Yes,
jumped over.
yes, Lordship. And earlier I also submitted two judgments, Lordship, with respect to Article 21. And this is my additional submission.
Heard Miss S.K. Nargis, Learned Council. I'll pass orders on Friday.
Chief, for two cases pending regarding that, I would like to place this one also. If any other cases pending against the person, no recovery has been from the petitioner. The petitioner has been implicated on the basis of statement by co-accused. Then Lordship completed in December for final has been co-accused enlarged on bail. In our case also co-accused enlarged on bail, Lordship. Who is the two? One we Duhon Gachani.
Heard Miss S.K. Nargis, Learned Council for the petitioner. Also heard Mr. S.C.K.R. Learned Standing Council, NCB. Let this case be listed for delivery of orders on Friday is 26. 26/7.
My lord, in this case, legal aid committee, it is discussed regarding this to, if it is exceeded 2 years, then there is discussion is there also. In the early of these cases, we have placed these judgments. If lordship would like to place, then I can place this.
You give whatever
Lordship,
is
I'm giving lordship another copy. Obliged to lordship.
without the. Logo, so itu staple money. Without side is staple money. Yes,
This matter was earlier heard by your lordship, and it was directed to ascertain the role of the petitioner, because my plea is that I took the lead in this vehicle. He is behind the bar for arrested on 6/10/2023 and forwarded on 7/10/23 on an acquisition of, my lord, that contraband, my lord, heroin was recovered from the vehicle. FI is the page, my lord, 12.
Mr. Parashar, have you
Hello.
gone through the case
But
diary?
case, yes, my lord, the scan copy is there, my lord. My lord, it is still in the stage of copy, my lord. Charge sheet on 31st of December 23. There are 12 witness. Last order on 3/4/24. It's fixed on 6/5/24 for copy. And my lord, huh? But contraband was recovered from the secret chamber of the vehicle. my lord. 3 persons are coming in the vehicle, my lord.
Yeah, should
All-
be in, my lord.
All this,
No.
there are secret chamber, not
Yes.
Your
like
plea
that.
is that you only took lift.
Lift, my lord.
What is the material to show that you took lift?
Apart from my readings, my lord, I have not, because it
Whether you made statement before the IO that you took lift,
my lord,
apart from your pleadings, because pleadings are later on developed.
yes, my lord.
During investigation, what are the materials? You go through it.
My lord,
Yes.
I have to.
Let him go through.
Then, my lord, can it be taken up on Wednesday, next Monday or Tuesday?
Okay. You go, in the meanwhile, you go through.
Today itself, my lord.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some time to go through the scanned copy of the case record before making his submissions. The prayer is allowed. Let this case be listed again on 29 August, 29 July.
One more matter left, my lord, in orders, my lord, for bail, my lord, 29.
29.
He is the petitioner, my lord. If call, my lord, then I will be free, my lord.
Okay, call 29.
29.
21, my lord, my name has not been shown, my lord.
29.
29, orders matter.
In 29, you are there.
Yes, my lord, only my colleague's name, my lord, has been shown, and because of that, some miscommunication was there, my lord. M.A. Chaudhary. Onto my lord, sign, my names were,
Then we'll direct to show your name and list it some other day.
my lord, my lord.
Item number 29. Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard
This tarikh dilan, no?
Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that as his name has not been shown in the cause list, he could not come prepared for this case and hence
Yes,
prays for some more time. The prayer is allowed. Let this case be listed again on
Monday, my lord, next Monday.
Mondays
29.
on 29/7. The registry is directed to reflect the name of Mr. M.A. Chaudhary as counsel for the petitioner in the cause list henceforth.
DPO.
Item number 6.
Lordship, it was in fact an appeal against a first appellate decree, which was dismissed on the ground of that there was no limitation for filing the appeal. So under section,
The appeal is barred by limitation.
yes, Lordship. So your Lordship was pleased to call for an authority on the point, but it is a point of limitation only. Whether it would be a question of substantial question.
Now,
of
what
law.
substantial question of law you are proposing?
Proposed substantial question of laws are Lordship on the merit and by additional affidavit Lordship.
No, where is? On merit, we cannot go into now because
Yes, Lordship, at this stage it is not possible. So far, the point of limitation is concerned, Lordship, when on a preliminary point.
whether in the first appeal also some order was passed that the appeal is barred by limitation.
Yes, that is the point, Lordship.
The-
So far, the original decree is concerned, it was expired, firstly. Nextly, Lordship, it was actually delayed by, in one sense, 657 days, and that was not condoned. But Lordship, the first appellate court was pleased not to consider the corona period guidance of the Honorable Apex Court. That was what was the crux in this case, Lordship. So, Lordship, out of 657, it comes to Lordship 232 days delay. Because Lordship, we could come to know only at the time of service of execution notice in the case. So in any case, apparently there is a patent error by not considering that the learned appellate court has committed a mistake in one sense. So even that need to be modified. That 657 days in view of the apex court guidance, Lordship, it does not come. In any case, Lordship, if the point of limitation is also considered, then it can be appeal lies, Lordship. Even if it is a second appeal, Lordship. SC 426, Lordship, AIR 2000 Supreme Court.
No, now in your additional affidavit,
Lordship.
you have proposed a
Lordship,
new,
a fourth point was given.
that may be the only point now.
Lo- For the time being, Lordship, yes, Lordship, for the time being, it can be considered because this is one of the aspects. Because my right is vitiated thereby. So on all counts, an appeal decided on the ground of limitation, Lordship, in fact, considered as decided as on merit, Lordship, by the apex court. Lordship, in that case, Lordship, the Shamsundar Sharma versus Pannalal, which I have already mentioned before your Lordship, 2005, 2005 Supreme Court 226, at para 9 by
Para 9 of
para 9 of Lordship 2005 AIR Supreme Court 226.
no, have you furnished the copy of that judgment?
Lordship,
You may read what is there in para 9.
Lordship. The specific question involved came to be considered by this honorable court in Messrs. Melaram. It has referred to so many cases, Lordship. Melaram and Sons versus the Commissioner of Texas, 1956, SCR 166. This court held that an appeal presented out of time is an appeal, and an order dismissing it as time barred is one passed in an appeal.
This court referred to and followed the view taken by the Privy Council and by this court in two respective decisions above referred to. This court quoted with approval of observation of Sagla CJ and KK Purvadewala versus Commissioner of Income Tax as follows. Although the appellate commissioner did not hear the appeal on merit, held that the appeal is barred by limitation, his order under section 31 of and the effect of that order was to confirm the assessment which had been made by the Income Tax Commissioner. In Shivram Singh versus Dairokar Kumar, AIR 1966 Supreme Court, 1332, rendered by four learned judges of this court. One of the questions that arose was whether the dismissal of an appeal from a decree on the ground that the appeal was barred by limitation was a decision in the appeal. The court held that this is relevant, Lordship. We therefore are of the opinion that where a decision is given in merit by the trial court and the matter is taken in appeal and the appeal is dismissed on some preliminary ground like limitation or default in printing, etc., it must be held that such dismissal, when it confirms the decision of the trial court, that is important, Lordship, on merit itself amounts to the appeal being heard finally and decided on merit, whatever may be the ground for dismissal of the appeal. So this being the position, Lordship, here it was more serious because Lordship, the original decree was passed ex parte. That is what is one of the point, Lordship. When we came to know, from that count, Lordship, there was no delay. However, Lordship, there is a delay and that has been brought on record. And the learned first appellate court, in fact, overlooked to consider that apex court decision. So very decision on limitation point, Lordship, was not correct in that sense and is to be considered by this honorable court. So far, if that is the consideration of point, Lordship, other points, because the ex parte decision should also be a decision on merit, even if it is ex parte. So the other points, Lordship may consider, because it is up to this honorable court to formulate the substantial question of law. Without formulating substantial question of law, this appeal cannot be heard, Lordship.
Heard, Mr. L. Talukdar, learned counsel for the appellant. This appeal under section 100 read with order 42, rule 1 and 2. Order 42.
In appeal, Lordship, in view of that consequential order is dated 25/8/23. In TA6, in view of, Lordship, order dated 25/8/23 in Miss J case number 30 of 23.
Rule 1 and 2 of the Code of Civil Procedure 1908 has been filed by the appellant, Messrs. Borpeta Agro Infra, impugning the appellate judgment and decree dated 25/8/2023, passed by Learned Civil Judge Senior Division in title appeal number 6/2023. And order dated 25/8/2023, passed by London Civil Judge Senior Division, Borpeta in Ms. J, case number 30/2023, whereby the first appeal preferred by the appellants was dismissed on the ground of barred by limitation. Third, no, stop. On considering the submissions made by learned counsel for the appellant as well as perusal of the materials on record, following substantial question of laws are framed in this case, in this appeal. Number one, whether the first appellate court was right in not considering the apex court directions to exclude the COVID-19 pandemic period while computing the delay in filing of the title appeal number 6/2023. Number two, whether mere mutation of the respondents in respect of Schedule B within bracket 3 suit land without having legally valid sale deed and possession would confer title to them to nullify a valid title and possession of the appellant. This is a number three, whether a plaintiff can secure a decree without proving his case merely because the suit proceeded ex parte in the absence of defendant. Stop. Issue notice to the respondents. How many respondents are there? 3 respondents. The appellant shall take steps for issuance of notice to the respondents through usual mode as well as through registered post with ID within 3 days from the date of this order, returnable on 17th of August 2024. Let the case record of 17th Saturday. Returnable on 16th. Returnable on 20 August 2024. Let the case record of title appeal number 6/2023 as well as Ms. J case number 30/2023 be called for from the Court of Learned Civil Judge Senior Division Borpeta. Registry to take steps for requisitioning the title appeal. You have a IA also.
I also lost it.
Execution is pending.
Execution is pending. We got the notice from the execution.
Now, in whose possession suit land is?
Property is in our possession, Lordship. Their claim is that they have purchased. On the last occasion, Lordship, I placed before your Lordship that out of their total land of 2 bigha 19 lesas, they have sold out 2 bigha 1 katha 16 lesas, etc. Whereas my land is 1 katha 10 lesa only. Those will be on the merit, Lordship. I am not on that. Lordship, what happens? There was no land at all in that dark. And if they have purchased this much of land, Lordship, how they come for executing the case, Lordship, when they have purchased the land? They had not been in any possession of my land, Lordship.
So we are issuing notice, let them appear and
Lordship, Lordship, because Lordship, if I am not allowed to or permitted to file even a WS, Lordship, in the cross-examination, I will harp on, Lordship, I may be permitted just to cross-examine in view of order 8 Rule 10, Lordship. That will do, Lordship, because they are not in possession.
No, no, that we are not deciding now. Now we have issued
Lordship,
notice.
Lordship, I
Let,
understand.
let them come.
Lordship. Meanwhile, it may be, sir, state Lordship, the execution may kindly be state
Which execution case?
execution case is Lordship. Title execution case number 82 of 2021, Lordship. At page 5, Lordship, of the IA.
Heard Mr. L. Talukdar, learned counsel for the applicant. This application under order 41 Rule 5 read with section 151 of the Code of Civil Procedure, 1908 has been filed for stay of the judgment and decree dated 28/8/2023 passed by learned Civil Judge Senior Division Borpeta in title appeal number 6/2023, which has been impugned in the connected regular second appeal number 212/2023. Issue notice to the respondents. The petitioner, the applicant shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 20 August 2024. As in the meanwhile, the appeal in the appeal, there is a sentence, admit the appeal. Appeal has been admitted and substantial question of law has been framed. The execution of the impugned decree shall remain stay till next returnable date. List accordingly on 20 August 2020.
Number 7. Deeply applied.
May it please, Your Lordship. Lordship, here in this case, only party has represented. Madam. So let the case be come up for admission hearing, Madam.
Admission hearing.
In fact, in last order, the Honorable Court has passed an order for disposal of the matter on today. But however, his senior counsel is not here.
It had otherwise.
Otherwise, today is the date
All
for
are-
disposal.
All are
of the-
represented.
But it has come up in orders column. Item number 6.
Seven.
Seven is in, why it is in orders column?
Yes.
We are fixing a date for hearing,
For admission,
For admission.
admission.
because the decree is there in our favor. The compromise decree was drawn up. It was so
They come up.
12. 12th of August.
One month. Ago case, so the appeal is admit as an 89 to cut it. Yes, heard Mr.
RS.
R. Islam, learned counsel for the petitioner. Also heard Mr. B. Datta, learned senior counsel assisted by Mr. S. Deka.
For
Yeah.
respondent number 1
Appearing
and 2.
for respondent number
1 and 2.
1 and 2. Also heard Mr. A.K. Gupta appearing for respondent number 7. Who is appearing for 6? And Mr. P.J. Soikia, learned counsel for appearing for respondent number 6. It is submitted at bar that this case is ready for hearing and it may be listed for in admission hearing column on when do you want
12th of August, my lord.
on 12th of August.
My lord, we are, I'm sorry, we are 1 to 5. 1 to 5.
B Datta 1 to 5.
1 to 5. All right.
The prayer is allowed. Let this matter be listed for admission hearing on 12th of August.
12th of August. Grateful. Oh, next.
I am taking a short break of 1.
Oh.
Item number 8.
This is FAO. We are before this honorable court against an injunction order. The injunction order was stayed by this honorable court. Now, meanwhile, the suit was withdrawn by the plaintiffs.
Then everything goes.
Everything goes. So, by that way, this FAO may be disposed of because the injunction order by the suit when withdrawn. Now, there is another development, madam. After the filing of the withdrawal petition by the plaintiff, 2 plaintiffs were there. Then the defendant, 2 defendants, they appear before the court and file an application for transposition. The court has allowed the transposition.
Before
And against that transposition order, we preferred a civil division petition. And therefore, that transposition order was stayed. This is the status of as on today.
and when the withdrawal was suit was withdrawn,
The suit was after the after we filed this first appeal against the order of injunction, that thereafter the suit was withdrawn.
now what is your submission?
Now the situation is that the suit is not now is not non-est.
No longer there.
Yes, because the withdrawal order was already been passed.
It is dismissed on withdrawal.
Is it dismissed on
What
withdrawal?
was the order passed?
The plaintiff was allowed to withdraw,
With
and
liberty.
along with the transposition application was also allowed. So therefore, my lord, the suit is there now
Transposition application under
under order 23.
what was the order?
Order was passed in favor of the transposition. The defendants were allowed to take in the shoes of the plaintiffs.
Then what will happen to that?
Then the learned lower court passed an order after the transposition was allowed. They were also allowed to file additional pleadings, to which we preferred an civil division petition.
A separate civil division.
Separate civil division, because there is a separate order has been passed, and whereby the additional pleadings was allowed, which is not permissible under law. Therefore, we preferred and the stay was granted. So unless the situation is, unless the transposed plaintiff came
No,
before this honorable
under
court,
which provision the transposition order was passed? Order 20? The
order 23, rule 1. 23. Yes, 1A, my lord.
1A, yes.
Yes. It has to be read with order 1, rule 10.
So the effect of transposition would be
Yeah.
that suit would continue if
Yes, suit is continuing. Now, the problem is that the transposed plaintiff, unless they file an application to continue as the respondent herein,
in place of the
They are
respondent.
not party to this
Yes,
civil
and
division.
therefore it is their duty, my lord.
Now who-
But the counsel who has appeared on behalf of the respondent, the original plaintiff, they cannot represent it.
Now who is representing? You are
I
for,
don't know.
I'm representing respondent 1 and 2 on behalf of A. Iqbal.
but you have already withdrawn.
Yes.
They are no longer a
And allowed in trial court.
That withdrawal is allowed. But that transposition petition was allowed. And later on, it was stayed by the High Court in Civil Division. So it is pending at the status is stayed,
status is stayed.
stayed. Now,
Now, this honorable court, without having any representation on the part of the respondent, on merit can dispose this. Subject to correction, my lord. What I understood that without because the original plaintiff,
no, in this division petition, you came against
an injunction order.
injunction order passed in favor of the plaintiff petitioner.
Yes,
But now they are no longer there.
no longer there.
Then
But the situation is, it is interesting point. But the plaintiff is still there. The plaintiff's names now changed.
oh, because of
Yes,
that is
because of the transposition.
that is also stayed.
So therefore, here in this instant, first appeal against order, we may be heard on the merit.
No, but then we have to wait till the decision of transfer, because then there may be a question of impleading them as
They make
respondent
they-
in this CRP.
Yeah.
Because without their participation, this injunction petition may not be this.
may not be proper to be considered. Correct.
So what is your submission?
So let the matter be fixed for another date, A2 revision petitions. Let the matter be come after 6 weeks now. Because the earlier, the CRP also not, any date is been fixed. No?
What is this interlocutory application? for?
Interlocutory application, that is the stay of the injunction order.
Okay, that's the interim stay was
Huh?
granted.
For 26 July, my lord, I'm sorry. The CRP is CRP number. CRP is on 26 July. So let both the matter come together. Let the matter be fixed on 26 July.
This
And the IA perhaps until further. The injunction order was stayed until further. So no need of any.
what is
extension.
your submission?
Yeah, we'll go-
You
we'll go.
you have no stakes. Heard Mr. B. Datta, learned in FO, main FO. Heard Mr. B. Datta, learned counsel, senior counsel assisted by Mr. S. Deka, learned counsel for the appellant. Also heard Mr.
MM Bhuya on behalf of Iqbal.
M.M.
Bhuya. On behalf of Iqbal.
M.M.
MM Bhuya.
M.M. Bhuya, appearing on behalf of Mr. A. Iqbal, learned counsel for respondent number 1 and 2. Who are 3, 4, and 5?
They are not represented here. There is the contesting defendant there. They are the vendors of this petitioner.
None appears for. Oh no. The notice on respondent number 3, 4, and 5 are yet to be complete. Await service report. Learned senior counsel for the petitioner has submitted that. For the appellant has submitted that the respondent number 1 and 2, who were the original plaintiff before in
Title suit number 155, 2020.
title suit number 155 slash 2023 pending before the Court of Learned Learned Civil Judge Senior Division, Dibrugarh, have filed an application before the trial court for withdrawal of the suit, which was allowed by order dated,
That I am,
which was allowed.
which was allowed.
However, and who filed transposition petition?
Transposition petition filed by?
Seven and nine.
Defendant.
7 and 9.
Defendant
number 7 and 9.
Of the suit.
of the suit. Now she will find the name also in the suit.
It is also submitted that
Page 20.
in the meanwhile, on this, the defendant number 7, 8, and 9 of the suit filed
7 and 9.
7 and 9.
And 9, yes.
Defendant number 7 and 9 of the plaint filed by the present respondent number 1 and 2 have filed have filed an application under Order 23, Rule 1A for their transposition as plaintiff in the said suit, which was also allowed by the trial court. However, Learned Senior Counsel submits that against the said order of the transposition, the present petitioners have preferred another
CRP number.
civil revision,
CRP
which was
IO
registered as
20
CRP IO
210.
210/2024.
And
Which
by
is-
order dated
24.
And
24/6.
in the said CRP, the operation of the transposition order passed by the trial court has been stayed,
Suspended.
Language.
has been suspended. The next date of the said CRP is the said CRP number
210. No?
210/2024.
210/2024 is fixed on
26/7.
26/7. Hence, Learned Counsel for the petitioner has submitted that this first appeal against order, this appeal may also be listed along with the
Yeah.
same said CRP on 26/7.
Yes.
The prayer is allowed. Let this appeal be listed along with CRP number 210/2024 on 26/7. In IA, heard Mr. B. Datta, Learned Senior Counsel, same Rakiba. In view of the order passed in the FAO number 22/2024 today, the interim order,
Already until further.
Until further.
Already.
oh, then that is not necessary.
Not.
Let this case be again listed on 26/7. when voted.
Get food.
Lord, case was fixed for instruction, my lord.
My lord. My lord, this case should be dismissed because they have been paid the discretional amount, my lord. And this petition was the act under which they are filing this interlocutory application is not applicable in this case. It may be dismissed, my lord. And our instructions are very clear. The discretional amount of 9,29,000 has been deposited to our account in the name of Syed Rahman, and that has been paid to them. And the other 1,85,000 they are claiming in this IA, that they are nobody to claim that amount. That has been computed to us under the law
and pay to the railway for administrative charges, my lord. And the revenue lawyers are present, my lord. Two of them are present.
What is the issue in this case? Matter.
My lord, the
My
petition.
lord, in that case, let me place the case. Actually, my lord, your lordship would be pleased to turn to page, page 13.
30 of the IA.
Yes, my lord. My lord, in a nutshell, what happened, my lord, amount of rupees 11 lakh 14,848 was decided for compensation against land acquisition, my lord. And thereafter,
You
what
were the
happened, my
owner
lord,
of the land.
out of that amount,
You were the owner of the land.
yes, my lord.
Okay.
Out of that amount, my lord, 9,29,040 was paid.
Okay.
So your lordship would be pleased to turn to page 13.
Page 13.
Yes, my lord.
Yes. What is this?
This is a letter, my lord, to the Joint Secretary, Government of Assam, by the Deputy Chief Engineer. So, with reference to the subject cited above, an estimate amounting to rupees 11,14,848.
No, why it has come up in orders column today?
Well, that is for instruction.
My lord, the IA had to be decided today.
IA is to be decided.
The IA I was referring to.
I,
IA number 1307 of 2024.
okay, this what relief you sought in this
My lord,
I?
in IA, my lord, my prayer before your lordship is this. Out of total amount fixed, my lord, 1,85,808, less amount has been paid to me. So I am claiming by this IA that the remaining amount at 1,85,808 may be paid to me.
And
That
what is your relief which you are claiming in the main appeal?
In the main appeal, my lord, my main appeal, my relief is this, my lord, that compensation decided by the district judge, my lord, is not proper.
Okay.
So that is another part. But thing is this, my lord, this less amount I am entitled to. That is my prayer before your lordship.
And your submission is that this.
My
amount-
lord, this first thing, the land was acquired on the year 10, 11,
Let me place
2010
the
year.
case, my
No,
lord.
let him,
Thereafter
let
my
him,
land
let
will
him
go.
make this.
So, my lord, what happened that your lordship is page 13, your lordship has seen with reference to the subject cited above an estimated amount, estimate amounting to rupees 11,14 so and so, my lord. That is to be paid. And thereafter, your lordship would be pleased to see page 14, my lord. So page 14, they want to say that I am entitled to 9,29,040.
No, in the,
Now your lordship will turn to page 23.
no, whether in the judgment of the district judge
Yes, my lord.
in LA 30 of 2016,
Yes.
any clarification was made as regards the quantum of the compensation 11,14,848.
Yes.
What part is for the administrative expenses of railway? Is there, is
now
any,
your lordship, there is the question. My land has been taken by the railway. My land has been taken by the railway and deputy commissioner acquired my land for the purpose of railway line construction. Now question arises, my lord. They want to say that some charges is to be deducted from the land compensation. My question is this, my lord. I did not approach before the deputy commissioner that deputy commissioner take my land. Land was taken by the railway. Whether that administrative cost, my lord, your lordship will
No,
turn to
on what
page
basis you are
23.
saying that?
Page 23, my lord.
No, just a minute. On
Yes,
what
sir.
basis you are saying that this amount of 1,85,000 is against administrative cost?
Yes.
What is your basis?
Yes,
What is the basis?
my lord,
Yes.
my lord, he has completed.
No,
I
no,
will see after he
now,
completes.
now your lordship will turn to page 23.
Page?
Page 23, my lord.
Now, what was the judgment
My lord,
before page
that
20?
amount, my lord, land, this is the letter to me, my lord, Saidur Rahman, by the additional district commissioner. They want to say, my lord, LA compensation amount 9,29,040 and estimated charge 15% on 929,040 rupees 1,39,000. Then my lord, contingency charge.
Where are you reading? At
My
page?
lord, I am reading 23.
Yes.
So, my lord, against item number 2 and 3, this deduction is illegal, my lord. Why that will be deduct from my amount? That cannot be. Because your lordship, my land has been taken by the deputy commissioner to construct railway for on behalf of the railway line, railway authority. So, my lord, I did not approach the deputy commissioner that take my land. Now what they are doing, my lord, they are deducting the amount as such. I approach the deputy commissioner. It is the need of the railway. Yes, all right. The deputy commissioner is entitled to these charges, my lord, establishment charges and contingency. Deputy commissioner definitely will take because there is some exercise, administrative exercise by the deputy commissioner. But why from my amount? This is the amount is to be realized from the railway. They cannot deduct the amount from me. That is my contention, my lord. That they are deducting this 1,85,000 from my due amount. Now your lordship would be pleased to turn to page 24.
Yes. Yes.
Page 24, they want to say, the authority want to say, they on the basis of this notification, your amount is deducted. That they want to say. Now your lordship would be pleased to see the act. My lord, this right to fair compensation, transparency in land acquisition, rehabilitation and resettlement act 2013.
Sudeep.
Right to fair compensation and transparency in land acquisition 2013.
Yes. Yes.
My lord, may I hand over this book?
No, I have it. You, which
your lordship has it.
section you are
Now,
referring?
now your lordship will turn to page section 3. Now, my lord, now your lordship will see page 24. They refer under paragraph A, this notification, cost of compensation under paragraph A of subsection 6 of clause 1 of section 3 of the right of fair compensation, so and so, my lord. Now your lordship will turn to section 3. Section 3, clause 1, clause I. Section 3 definition, my lord, clause I. Clause I, page 13, if it is the same book, my lord, page 13.
Yes, clause I, cost of
Yes, clause I,
acquisition.
your lordship got it. Cost of acquisition. Cost of acquisition includes amount of compensation, which includes solitarium, any enhanced compensation ordered by the Land Acquisition and Rehabilitation and Resettlement Authority or the court, and interest payable thereon, and any other amount determined as payable to that effect by the families, by such authority and court. Now your lordship will turn to page 14. 14, 6, paragraph A, my lord. Administrative cost. The lordship got it.
Yes,
Serially 2, 3, 4, 5, 6. Administrative cost. Paragraph A, capital A.
yes,
For acquisition of land, including both in the project site and out of project area lands, not exceeding such percentage of the cost of compensation as may be specified by the appropriate government. So, my lord, this notification issued by the appropriate government. Appropriate government say that these are the compensation can be realized. Now, your lordship, it is right that government can issue notification for compensation. Now, question arises, who will pay the compensation for acquisition? My contention before your lordship is this: it is the requirement of the railway authority. Railway authority wants land. So land has been taken for acquisition. What exercise has been done by the administrative authority, railway is liable to pay that compensation to the administrative authority, not from my money decided for pay me to land acquisition. So, my lord, my humble submission before your lordship has come to the provision of this section under which this notification has been issued. It is not said where from that compensation will be realized. Yes, appropriate government will issue notification. Notification is issued, but it is not said that from my compensation amount, they will realize this administrative cost. That's a wrong way that has been realized from me, my lord. Simple analogy is this, my lord. I did not approach the authority. Railway requested the administrative authorities that we want some land for our project. Land has been acquired. Now, from me, that cost is realized, my lord. It's a completely unreasonable thing. And this notification does not say, the provision of law does not say that it will be realized from my amount. Then who will pay this compensation? Why Deputy Commissioner will realize from me? It should be realized from the railway authority. That is the illegality, my lord, and that is discriminatory against me. It is illegal completely. It is not said that from me it will be realized. When I approached the Deputy Commissioner, my lord, Deputy Commissioner replied this, that this notification, by virtue of this notification, your amount has been taken away. Now, question is, this notification does not say, law does not say that from me that amount will be taken. How they can take away?
what was the compensation amount which was fixed?
11, my lord.
But,
That is 11.
but in
11,
Annexure 7, it is
11 lakh 14,840.
No,
I
that
have
is
referred, my lord, page 13,
page.
page 13. It is the joint secretary by the deputy chief engineer with reference to the subject cited above an estimate amounting to rupees 11 lakh.
What was the compensation amount
14,848.
fixed in the LA case?
Yes. Yes,
LA
my
case number 30.
Yes, my lord. LA case.
In LA
The
case,
judgment is in the appeal, my lord. It starts at page 29,
what was the compensation amount fixed there?
6 lakhs per bigha.
So at that rate, what is the,
It would be something like that, 9 lakhs something. The railways had calculated it.
No, my lord. Railway, that is the thing, my lord. Railway calculated this amount, my lord. 11 lakh 14,008 for it. It is the deputy engineer NF Railway said to the joint secretary, Government of Assam, reference to the subject cited above and estimate amounting to rupees 11 lakh 14,000.
no, your miscase cannot be decided without facts being clear.
My lord.
First of all, what was the compensation amount fixed by the judgment
So Lordship, for that purpose, my lord may kindly peruse page 38.
of?
Page 30 of the LA appeal, Lordship. LA appeal.
Page 38.
The Honorable District Judge's order is that, Lordship, it should be calculated 6 lakhs per bigha, Lordship. And petitioner's land is, Lordship, 1 bigha, 1 kotha, Lordship, page 38, Lordship.
Six lakhs per bigha. At that rate,
6 lakhs per bigha
6 lakh
and measuring
and
on
land
bigha,
measuring,
1 kotha,
Lordship,
5
1
paisa,
bigha, 1 kotha, 5 lessons, Lordship.
with interest at the rate of 6% per
If
annum.
we convert it to the Lordship without interest, Lordship, then it will goes to Lordship 7 lakhs 80,000, Lordship, as per the Honorable Court District Judge's order, Lordship. And after calculating the interest, Lordship, it's so Lordship may kindly come to the miscase, Lordship. Miscase page 23, Lordship.
page,
Page 23, Lordship.
yes.
It has
Mr. Sheikh,
Before that, Lordship may kindly peruse that documents from the railway.
no, before that, let me be more clear about this.
Lordship.
Mr. Sheikh, on what basis you are saying that your compensation will go up to is amounting 11 lakhs? On what
On the
basis?
basis of this letter, my
It
lord.
Letter
cannot-
is not, letter is, your basis should be the judgment of the district judge.
Just
On the basis
judgment
that
of the
the
Judgments, it
Hello.
lays down the rate.
Let them then place before
The
your lordship
letter
the
which was-
No,
calculation.
but you are preferring, you have preferred this interlocutory
My
application.
lord, I prefer this, I am a lot on the basis of this letter.
that letter is
Letter
If
does
they
not
want
give
to
it.
say, if they want to say,
That
"No,
letter
I'm
will
entitled
say-
to less amount."
that letter nowhere reflected the decretal amount of the petitioner. So for the decretal amount, my lord may kindly peruse that letter, Lordship. That letter in the page, Lordship, that which letter was referred by my learned senior friend, Lordship. It's include all the administrative charges, Lordship, and establishment charges. So Lordship may kindly first page of this particular letter, Lordship. The decretal amount after adding the 6% interest, Lordship, it goes to 9 lakhs 29,040 rupees as per the Lordship judgment of the district judges, Lordship. And the other total amount, Lordship, the amount
And
which
this
was
amount has been paid to you. You have received this.
that
Right.
part is
That
paid,
amount
Lord.
I have paid.
That is paid, Lordship.
You are asking for that 185, which is shown as establishment charges and contingency charges.
Establishment
My
and
lord, my contention before your lordship.
that particular
that
charges was,
administrative
Lordship.
charge has been taken away from me, my lord. That is my contention.
No, it is
No,
not
it
taken.
is not from him, it is from
It
the railways,
appears that
Lordship.
it is not from you,
My lord.
because your entitlement is at the rate of 6 lakhs per bigha.
6 lakhs per.
If
bigha.
you can show to this court that at that rate, it comes to 11 lakhs, then you may have a case, otherwise not.
That administrative charges and contingency charges are lordship from the railways by the administration lordship. Not,
No, I have understood.
not from the lordship.
Yes, Mr. Sheikh.
Well, in that case, my lord, let them place the estimate before your lordship. That not this 11 lakhs 14,848 is not my due.
You have not filed any objection, written
Did not
objection.
file.
Lordship, objection is not required. I am for the railways lordship. Objection is not required on the
No, my
basis
lord,
of the face of the
My
record
humble
lordship.
submission before
Face
your
of the
lordship.
record lordship.
My
And
lord,
otherwise,
I have a grievance before your lordship.
No, but your claim is based, not
a-
based
there
on
should
the,
be basis lordship.
No, my lord, let them file affidavit.
no, why it is,
Objection.
you cannot,
Objection is necessary, my lord.
no, you cannot compel them unless you show your basis for
Lordship.
seeking
No, my lord,
that
why? My basis is this letter, my lord.
letter
This
cannot
30.
be, letter
Yes,
has specifically mentioned that the compensation amount is 9,29,000.
Lordship. And other.
Then it cannot be the basis. Your basis may be the judgment of the district judge in the LA case. Because it lays down the
Yes,
rate.
yes.
It lays down the rate.
Yes, ma'am.
If you are not given the compensation according to that rate, then you may agitate.
Lordship.
But if it comes to 9,29,000, then you cannot have a case
No,
for.
my lord, my learned friend was submitted. This is the oral submission. Let them clarify by filing an objection. Where is the problem?
No, you cannot compel them. If matter can be decided, will you file a written objection?
But if they,
Our part is not required. If
my
district
lord,
administration lordship,
if they
once-
without
once they can
objection, my
lordship.
lord. If
once they
my,
can, otherwise lordship,
Railway has already deposited.
we have
need to-
already
yes, I have
deposited,
received it.
deposited that decretal amount and he has received and other administrative charges was also deposited lordship, it's amounting to 11 lakh so and so. Lordship, that was
It appears
deposited.
that in this case, you don't have a case.
Lordship.
No, my lord, I don't have a case, but I place a case on affidavit, my lord. Let them object to that. Let it be in writing,
Not necessary.
my lord. If your lordship decide without objection, my lord, your lordship can decide.
No, you just tell me one thing. How much amount comes after computation of the
My lord, here my.
this 1
my
bigger
humble-
5 quotas of
here-
land.
Here, my humble submission before your lordship. Calculation is done by the deputy
No,
commissioner.
you do your calculation.
Calculation is done by the railway authority, my lord. My calculation will not do, my lord.
No,
My calculation will not do.
you,
My lord, they are the authority to pay the amount. Let them say that that is the calculation and this much amount he is entitled to. In writing, my lord. Now, why they are not placing this objection before your lordship? They are to calculate. How I will calculate? And my calculation, they will not pay me.
you file a written objection.
So
to that.
lordship, the IA, my lord, may
Where
kindly
is the
page
problem?
16 of the IA.
Problem to
No,
file
no, I
objection.
have understood the matter,
Page 16 also.
but
lordship.
let this be on record also.
Page
Yes.
16 also the honorable court's order is there.
Let them
Where
place.
the decretal amount is lordship reflected. Page 16 of the IA lordship.
That's all right, my lord. I am saying that
Page
I will not
16
calculate.
And against that,
Calculation will be done
against
by
that
the
lordship,
railway
against that
authority.
petitioner has nothing preferred and appeal, nothing was done by the petitioner. So page paragraph 4 lordship.
Mhm. Yes,
That
yes.
is the order of our High Court lordship. Paragraph 4 and subsequently paragraph 5 lordship.
Paragraph 4 of what?
No, that calculation, how much it comes.
Lordship.
My lord, let me clarify the legal point, my lord. From
My lord,
the
my humble
district-
submission before your lordship. I am
My
leaving
lord-
to your lordship. Why
my
is
lord,
the
the
problem
hill-
to file objection?
the
Already
land
they are
was-
submitting many things.
My lord, let me clarify the thing. Let me try to say what has come from our end.
Yes,
Let me inform the court about that.
yes.
from our end, what we know from the papers, we acquired the land in the name of the railways in the year 10 and 11. At that time, the Land Acquisition Act 1894 was in play. And the appeal, let me show that in the appeal itself, that is their document.
No, Mr.
It is at page 1, they have admitted that it was the land was acquired under section 18 of the Land Acquisition Act 1894. So in that same case, they are filing an interlocutory application under the new act of 2013. So how are they going to get relief? How is it legally possible, my lord? This is a different act for new acquisitions, not in under land acquired in 10 and 11. We are referring to the land that was acquired in 10 and 11, not in land acquired after 2013. They are filing this interlocutory application under section 60 of the Right of Fair Compensation Transparency Act in Land Acquisition Rehabilitation Settlement Act 2013. So how is this this sustainable, my lord, this interlocutory application? And in facts also, I think I agree with entirely with the railway lawyer, Mr. Gogoi, that in facts also he has shown, and in law I have shown that this application is not sustainable, my lord, under the law, because it is under the Land Acquisition Act 2013, which is not applicable in this case. And they have admitted that in their appeal itself. At least I will not be getting involved in an illegal case, man. This is illegal, man.
No, otherwise on facts also. Why this?
So position of filing an affidavit will come when something is legal, my lord.
No, you cannot be compelled unless court says. But it would be good if it is on record that on what basis
Instruction to that this paraphrase has not come, my lord. Is the problem.
then you seek some time. I will give you. Only just you have to bring on record that the computation part, on what basis that
Yeah.
9,24,000.
I can take say phrase instruction.
Okay,
6 weeks time maybe. given.
okay, we are.
My lord, today is fixed for instruction. And
No,
now
otherwise,
another 6
because-
weeks, my lord.
because
Now your lordship, what my learned friend pointed out, my lord, your lordship would be pleased to take the LA appeal, 7 of 2022. Before your lordship,
yes,
that 84 Act, 7/2022. So my lord, my appeal was under section 54.
no,
of
Mr.
the-
Sheikh, though he has raised a
Well,
point of law,
okay.
but the question on facts,
Yeah.
it appears that you don't have a case.
My lord, only thing is
You-
this, my lord,
you-
let them place on record.
You are not basing your case on the facts
Ah.
available before you. So therefore, let them place,
That
take
already
6 weeks.
your lordship pointed out.
Yes, I will have to
Let
take
me-
instructions, my
You,
lord.
you seek instructions as to on what basis the compensation of 9,24,000 has been computed. Basis appears to be apparent from the judgment of in LA case that, but let that on record from your side. You
Yes.
file an affidavit. Heard Mr. M.A. Sheikh, learned counsel for the applicant. Also
And my
heard.
lord, the letter the railway lawyer had placed, that is actually our letter. That had come, my lord, from our side. So that is all, I mean, that may be placed on record, man, that letter.
This letter is from railway to deputy commissioner.
Yeah.
Also heard me. Oh,
Yes, my lord can keep that letter, so affidavit may not be required, my lord.
No, it only shows that how much has been sanctioned. Also heard Mr. K. Gogoi, learned standing counsel, learned central government counsel, appearing for railways, who has placed on record a letter dated 10/3/2023 addressed to the Deputy Commissioner Bongaigaon from Deputy Chief Engineer NF Railway Jogi Gopa, wherein it has been mentioned that an amount of rupees 9,29,040 has been sanctioned by railway towards compensation in favor of Mohammed Syed Rahman against title suit within LA, within bracket LA, number 30/2016. The letter, which is marked as X, be placed along with the record of IA within bracket C, case number 1307/2024. Who else is appearing?
I am
Mr.
appearing for the
Bhattacharya. What is
Deputy
your name?
Commissioner, K.K. Bhattacharya.
Also heard Mr. K.K. Bhattacharya appearing for,
For the Deputy Commissioner, State of Assam.
you are government advocate.
Yes.
Government advocate Assam, appearing for the state of Assam, who submits that the interlocutory application filed by the applicant/appellant is not maintainable in as much as same has been filed under section 60 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2038, whereas the land was acquired under the provision of Land Acquisition Act 1894, which year is?
2013,
No, land was acquired under which act?
Land Acquisition Act 1894.
1894. Stop. Learned government advocate has also submitted that at the rate of 6 lakhs per bigha, which was fixed by the court of learned district judge Bongaigaon in title suit within LA number 30/2016 in judgment dated 4/2/2021, the compensation for land of the applicant/appellant measuring 1 bigha 1 kata 5 lechas comes to rupees 9. Where is that? 929,040 only. However, he submits that he may be allowed 6 weeks time to seek instruction and file an affidavit to that effect if necessary. The prayer is allowed. Let this matter be listed after 6 weeks.
Ablaji.
Yeah, please, your lordship.
You have to repeat what you said.
There is a delay of 250 days.
250 days.
250 days. Filing first appeal against order by the this is the application filed by the petitioner by party decree.
Order 9 Rule 13.
Order 9 Rule 13 application. That was dismissed. Against that dismissal order, this appeal has been filed. There is a delay of 250 days filing this appeal. So this IA has been filed saying for explanation of delay. Lord, the case of the petitioner is that she has been suffering from liver ailment since 2017. And I have annexed the complete medical record of the petitioner. He had to undergo liver transplantation at Apollo Hospital, Chennai. That is at page 5, paragraph 4 of my IA. That the applicant states that due to grave and compelling circumstances was prevented from contesting the matter as she was suffering from liver ailment since 2017, which consequently led to her liver transplantation at Apollo Hospital, Chennai on 9/5/2003. Then the Lordship may kindly see paragraph 5. That the applicant respectfully states
What was
that
the date of dismissal of 9/13?
Lordship, the date of dismissal of the Order 9 Rule 13 application is 9/3/23. That is at page 6, paragraph 5.
Okay.
Subsequent paragraph 5, I have said that the applicant respectfully states that even though the ex parte judgment and decree was delivered by the Honorable Court on 3/3/22, the applicant, by engaging one so-and-so advocate, had filed an application for setting aside of the ex parte judgment and decree on 28/3/22 by executing the required wakalatnama, which was apparently not filed by the said counsel, which led to the dismissal of the application under Order 9 Rule 13 on 9/3/23. Then in paragraph 6, I have said that the applicant respectfully states that although the liver transplantation took place on 9/5.
No, your contention is that when you filed the application for setting aside decree which was not filed,
It was filed, but the counsel for the appellant did not file the wakalatnama which was executed by me.
Okay.
Instead, some other counsel appeared in the court below. And if your Lordship sees the memo of appeal, things will become clear. I have annexed all the entire certified copy.
no, in para 5, what you intend to say?
What I intend to say is that although the ex parte judgment and decree was delivered on 28/3, and this application for setting aside the ex parte decree was filed in time, but it was dismissed.
Within time.
It was filed in time, but it was dismissed on 9/3/23 on the ground that the engaged lawyer, he did not file the wakalatnama before the court.
So that was the only ground.
That was the only. Lordship may see the order. That is with in the memo of it.
No,
party represented by the advocate, petitioner without any step submitted for adjournment of the case on perusal.
This is the order of dismissal. 9-3.
Against this order, I filed this first appeal in this court. There is a delay of 250 days in preferring the appeal. So that is why this IA has been filed.
One is
Subsequently led to liver transplantation. Even after liver transplantation, I am suffering from post-operative complications. So that is the reason why I could not approach this honorable court in time. For that, I have annexed my entire medical record.
anything else? Yes.
But there is a technical issue that needs to be decided by this court.
After lunch. I have passed.
Yes.
Okay, item number 16. This matter before any other court without me. The date to be fixed by registry.
Pertaining to the Kohima bench, delivery of judgment, item number 1.
For reasons mentioned in the judgment, the appeal is dismissed.
Item number 2.
Judgment to the local judgment. For reasons mentioned in the judgment, this appeal is partly allowed. The insurance company is exonerated from the liability of paying the compensation awarded to the respondents, number 1, 2, 3. And same is modified to the extent that respondent number 4 is liable to pay the compensation amount to the respondent number 1, 2, 3. The 50% of the compensation amount which has been already deposited and received by the claimants may be recovered by the insurance company from the owner of the vehicle. The remaining 50% shall be paid by the respondent number 4 / owner of the vehicle to the respondent number 1, 2, and 3 claimants. The registry of principal seat is directed to send back the case record of this MSC, this appeal, along with the MSC case number 07/19 to the Kohima bench immediately. With above observation, this appeal is hereby disposed of. কিন্তু ভিতর দিও mix up না।
May I please, Your Honor?
Yes.
No, there is a technical issue before answering, going into the merits of the case, my lord. May I please point out an issue, a technical issue, my lord. May I please take my lord to the paragraph number 1 of the application that he has sent.
Yes.
My lord, has it. Before that, my lord, the title suit matrimonial number 112 of 2019 has been decreed by the learned additional district judge Tinsukia on 16/3/2022. So that is the final order which has been passed, my lord. Subsequently, they came up with an application under Order 9 Rule 13 filed on 28/3/2022.
and the order of dismissal is there on 9/3/2023, my lord. 23, my lord. Now, if I may take my lord to the paragraph number 1. That being highly aggrieved by the dismissal with the judgment and decree dated 16/3/2022 passed by the additional district judge to Tinsukia in title suit number so and so, and the consequential dismissal of the order 9 rule 13 petition for setting aside of the ex parte judgment decree dated 16/3/2020. So firstly, prima facie from this particular petition, and I'll show from the petition which he has filed, which is yet to be numbered after allowing this particular petition. His prima facie challenge is the decree which has been passed. But very unfortunately, this particular application has been filed for craving leave for filing an FAO. Well, these are two separate provisions of filing an FAO and filing a regular first appeal. For filing a regular first appeal, he'll have to come under order section 96(2), order 41 for regular first appeal. But he is coming under order 43 rule 1D for FAO.
Order 43 rule?
Rule 1D, no. FAO. So for challenging this particular judgment and decree, he'll have to file an application under 41 and section 96(2). And he seeks liberty from this court for filing an application, for filing an FAO, not a regular first appeal. But in the prayer portion of this particular, as it was transferred from this particular paragraph, as well as from the prayer portion, no doubt I have not been served with a copy of the application as of now, the appeal as of now, but his prayer is very specific. He prays for setting aside of the decree passed by the additional district judge in Sukyamala. Prima facie, his application is not maintainable. He needs to clarify on that, because if today this particular application is allowed, then he will go, when the main application is registered, finding this particular prayer, he will withdraw it. Then he will again come under section 5 of the Limitation Act, praying under section 14 of the Limitation Act for condonation of the delay. No, that the council has wrongly filed an application first, my lord. So this is the technical issue, my lord, that my lord needs to consider before allowing this particular
But he is also challenging the order of dismissal.
Yes, my lord.
Order 9 rule 30.
My lord, he can challenge it in way of an RSA also, or I'm sorry, my lord, regular first appeal also. His first prayer is for setting aside of a judgment and decree, my lord, which is covered only under order 41, my lord. And he has filed his application under 43D, 1D.
Then the relief which he is not entitled to,
My lord,
that will not be granted.
that won't be granted. And if that not be granted at the time of the final registration of the matter, because I'll specifically raise an objection, then he will withdraw that particular petition and he'll file an application again under section 5, my lord.
How you can anticipate what will be?
Then, my lord, he will come under section 14 of the Limitation Act, my lord. He'll say that a wrong application has been filed by the council, so therefore I may be granted. Ultimately, I am the sufferer. A decree has already been passed in my favor. Again, I'll have to come and again this same process will go, my lord. That is the reason why I'm raising this issue before this honorable court. Otherwise, my lord, my scope in objecting this particular application under section 5 is very limited.
Then today we are concerned with section 5.
My lord. Then if my lord allows this application, then a specific observation needs to be there, my lord, from my side that I have objected, my lord, and I have put it to his notice that, my lord, this application is not maintainable as he has filed it under and he has challenged this particular.
That question may be raised when that application is under consideration.
My lord, if that observation, with all due respect, my lord, this is rightly fallen from your, my lord. If that observation is not observed, my lord, if that my submissions are not observed, then it will ultimately grant him a liberty under section 14 of the Limitation Act, my lord. If I may take, my lord, to section 14 of the Limitation.
You may again raise objection.
My lord.
While assuming it now appears that you are not opposing.
I have not entered into the merit of the application. This is the technical issue. Merit I will enter, my lord. There merit, because he has specifically stated, my lord will kindly see.
No, but now the FAO is not before us.
FAO is not before, my
If
lord.
we go very technically like
yes, my lord. Yes, my lord.
this
FAO
FAO
is
is not yet to be registered.
My lord.
So we may not consider what he is seeking as.
My lord, but
assuming that his application is not allowed.
my lord.
then your submissions will be of no use.
Ultimately, my lord will have to consider one aspect, my lord, that section 5 application is only for condonation of a delay for filing of an main application. And I am raising an objection as regard to the main application itself, that the condonation which is seeking for filing the main application itself is not maintainable. Certainly that would come in the, after registration of the, I'll get a specific chance after registration
Yes,
of the
you will
main
get
application.
chance.
My lord, but my contention is, my issue that I am raising before this honorable court is that, my lord, once this application is allowed, if assuming that his application is allowed, the main suit will be registered, and ultimately a point of time will come.
No. Condonation delay application, if it is allowed,
If it is allowed, my lord.
then his first appeal would be registered.
My lord.
And that
His FAO, my lord, not
F-
first appeal. His FAO.
Yes, FAO would be registered.
Yes, my lord.
This is first appeal against
Order.
order.
My lord.
Would be registered and it will be considered
My lord.
on its own merit.
My lord.
Then you can raise all objections.
My lord, if my lord doesn't observe this particular objection of mine, then when the time will come for, because prima facie this application is not maintainable. Ultimately,
Which-
his FAO would be not maintainable.
Section 5 application.
No, my lord. His FAO would not be maintainable. Because if he has challenged this particular
No, on
judgment and
that
decree.
maintainability issue,
My
you
lord.
can raise objection later
Certainly,
on
my lord.
at appropriate time.
Certainly, I'll raise, my lord. But the issue that I'm highlighting before this honorable court is as regard to my problem is regard to section 14 of the Limitation Act, my lord.
But that is on many assumptions.
My lord.
Now we cannot go on assumptions that let us first hear your objection to section 5
My lord.
condonation of, if you have no objection to condonation of delay,
I have, my lord, I have.
we'll restore it, then we'll hear the FAO. There you can raise any objection.
Then my prayer would be, my lord, along with my objection in the FAO, in the section 5 application, the objections which I have raised as regard to, my lord, that may be observed, my lord. That may be brought on record, my lord. That is only my prayer, my lord.
Okay. What are your objections?
Objection as regard to, my lord, that this particular application in para 1, which he has filed in the IA, my lord, section 5, he has filed an FAO challenging of this particular judgment and decree, which is not maintainable under an FAO, for which he'll have to file a regular first appeal, not an FAO.
No, from where you are saying that he is challenging that?
My lord, that being highly aggrieved by the paragraph number 1, my lord, of the application,
No,
that being highly aggrieved by this and dissatisfied with the judgment and decree dated 16/3/2022, passed by the additional district judge to entitle suit matrimonial and consequential dismissal of the order 9 rule 13 petition. So first he is challenging the judgment and decree, my lord, under
No,
an
he is
FAO.
not challenging. He's
My lord, may
only
kindly,
aggrieved.
my lord, may kindly take up the FAO then, my lord, for a moment. The main order. It is very specifically written in the FAO. The prayer of the FAO, my lord. He prays for setting aside of the ex parte judgment and decree dated so and so.
Where are you reading?
My lord, the prayer portion. I have not served the copy. I've just noted it from the prayer, my lord. Prayer in the FAO.
Judgment and decree cannot be set aside in FAO. Only order dated 9/3/23 may be considered in effect.
Lordship,
No, you have prayed for setting aside judgment and decree.
no, I am only concerned about about dismissal of my order 9 rule 13 application.
In FAO also.
FA also.
That his prayer doesn't say so, my lord.
Okay, I'll make,
Yeah, that
reflect,
Lordship will clarify
Clarify.
that.
I'll reflect your
Yeah.
submissions
My submissions may be reflected,
as
my,
well as his reply there.
Yes.
my lord, because if
My
he,
prayer is limited to that.
then he'll have to file an amendment application there, my lord.
What happens later on? We'll
First, let the matter come up for admission.
My lord, then my lord, if I may take my lord to the IA, my lord.
You are still opposing.
Yes, my lord, still opposing. No?
Yes. Yes.
Ultimately, it's on my lord. If my lord's allowed this, then it's a
No,
different thing.
it is on.
My lord, the order 9 rule 13, initially the decree has been, if I may take my lord to page number 6 of the application, my lord. Here he mentions to date in the first paragraph. Firstly, the ex parte judgment and decree that is on 8/3/2023. Then the application, his dismissal of the application on 9/3/2023.
Where are you reading?
My lord, page number 6, the first paragraph, my lord.
Okay. Yes.
The first date is of the ex parte judgment and decree, my lord, 28/3/2022. Then thereafter, the date is, my lord, order 9 rule 13 on 9/3/2023. This is the dismissal date of that particular application. Now, my lord, 90 days after 9/3/2023 expires on 7/6/2023. And as to his contentions in paragraph number 6, his liver transplant took place much before that, 9/5/2023. And his documents which he has submitted are very much limited as to that date only, my lord. And the law regarding section 5 is very clear, my lord, that each and every day delay has to be explained. And this is not a 1-2 days delay, my lord, a delay of 250 days. So merely making a vague submission as to that regard won't suffice the need, my lord.
Okay. Yes.
That is my
Heard. Mr. This is item number?
Item number 30.
30, my lord.
Heard Mr. P. Bhaumik, learned counsel for the applicant. Also heard Mr. S. Borthakur.
R. Sensor, my lord. I'm praying for his water.
Heard Mr. R. Sensua, learned counsel for the respondent. Learned counsel for the opposite party. This application under section 5 of the Limitation Act, 1963 has been filed by the applicant for condoning the delay of how many days?
250 days.
215 days.
50.
250 days in preferring the connected first appeal against order challenging the ex parte order dated. No, this challenging the order dated 9/3/2023. This 9/3/2023.
16/3/22. Sorry, 9/3/23.
9/3/2023 order was ex parte or inter.
Lordship, the council could not appear because Wakalatnama was not filed.
So
Lordship
it
has
was,
pinned the order.
it was an ex parte order. Challenging the ex parte order dated 9/3/2023 passed by the Court of Learned Additional District Judge number 2, FTC Tinsukia in Miss J case number 5/2022, whereby
If I may, my lord, trouble my lord for a second. The 9-3 order has been passed for non-prosecution by the appellant, my lord, by him. It's not for, my lord,
Okay.
it's not an expert.
Challenge, no, don't mention anything. Challenging the
His 913 application has,
order dated 9/3/2000 ex parte to kate di, no?
he was the original defendant in there, my lord. Suit
But-
proceeded ex parte against him. Thereafter, he came up with this particular application. Setting
Learned,
aside of the
learned
judgment.
counsel for the applicant has submitted that the respondent herein filed a title suit seeking a decree of divorce, before the court of learned additional district judge number 2 Tinsukia, which was registered as title suit within bracket M number 112/2019. The said suit was decreed ex parte against the present applicant. Stop. Present applicant on when it was decreed?
16/3/22.
On 16/3/2022. Learned counsel for the petition applicant has submitted that when the petitioner came to know about the said ex parte decree, she preferred, your wife,
Yes.
she preferred an application under Order 9, Rule 13 of the Code of Civil Procedure, 1908, for setting aside the ex parte decree. And however, the said application, setting aside ex parte decree, which was registered as Miss J case number 5/2022. Stop. Learned counsel for the petitioner has submitted that by order dated 9/3/2023, the said Miss case was dismissed by the trial court for
Non-prosecution.
non-prosecution. As the applicant failed to file wakalatnama in the said case authorizing his engaged counsel in the said case. Stop. Learned counsel for the petitioner submits that the instant submits that the challenging the said order dated 9/3/2023 passed in Miss J case number 5/2022. The applicant has preferred the connected first appeal against order. However, owing to the ailment of owing to liver ailment by which owing to liver ailment of the applicant, there has been a delay of 250 days in preferring the connected first appeal against order. And therefore, the instant interlocutory application has been filed for condoning the said delay. Stop. Learned counsel for the petitioner has submitted that the petitioner has been suffering from liver ailment since the year 2017, which ultimately led to her liver transplantation at Apollo Hospital, Chennai on 9/5/2023. It is also submitted by learned counsel for the applicant that after the operation, the applicant is still undergoing post-recovery stage and has to undergo medical treatment from time to time, which has also added to delay on her part in preferring the first appeal against order, the connected first appeal against order against the impugned order dated 9/3/2023. Learned counsel for the appellant has submitted that, applicant has also submitted that the cause shown by the applicant for delay in preferring the connected FAO, full likhit first appeal against order, FAO was beyond her control and may be regarded as sufficient cause which prevented her to file the connected FAO within the period of limitation, and hence learned counsel has prayed for condoning the delay in preferring the connected FAO. Stop. On the other hand, Mr. R. Sensua, learned counsel for the respondent, has raised a preliminary objection to the effect that in the FAO which has been filed delayedly by in the connected FAO which has been filed by the applicant has challenged not only the order dated 9/3/23 passed in Miss J case number 5/2022, but also the judgment and decree dated 16/3/2022 passed in title suit within bracket M number 112/2019. Stop. Learned counsel for the respondent submits that the judgment and decree passed in title suit within bracket M number 112/2009 cannot be challenged under an appeal referred by the applicant under order 43 rule 1 within bracket small d of the CPC. But for that, he has to pray for a regular first appeal, which has not been done by the applicant in this case. Learned counsel for the respondent has also submitted that though the applicant has taken the plea of undergoing liver transplantation which was conducted on 9/5/2023, the applicant had sufficient time to file the FAO after the said date, as the limitation for filing FAO extended till the month of June 2023. And hence, learned counsel for the respondent has also submitted that the applicant has failed to justify the delay caused for the entire period, or failed to justify the entire period of delay which is required for condoning any delay under Section 5 of the Limitation Act 1963. And hence, he has vehemently opposed the prayer for condoning the delay in preferring the connected FAO by the applicant. Stop. I have considered the submissions made by learned counsel for both the sides. It is pertinent to mention herein that while making submissions, learned counsel for the applicant has also submitted that though in the prayer portion of the FAO, in the prayer portion of the connected FAO, the applicant has also prayed for setting aside the judgment and decree dated 16/3/2022, passed in title suit within bracket M number 112/2019. However, he will not be pressing for the same, and the FAO would be limited only to against the order dated 9/3/2023, passed in Miss J case number 5/2022. The documents submitted, the medical documents submitted by the applicant shows that the applicant was suffering from liver ailment and ultimately undergone a liver transplantation on 9/5/2023. It also appears that the applicant is also undergoing post-operative treatment after the said date. Though the learned counsel for the respondent has submitted that the applicant could have preferred the connected FAO within the period of limitation, as she was operated only on 9/5/2023, and the period of limitation for filing the connected FAO extended till the month of June 2023. However, considering the nature of ailment suffered by the applicant in the relevant period, this court is of considered opinion that a liberal and justice-oriented approach has to be taken while considering the application for condonation of delay. More so when the order which is under challenge in the connected FAO also appears to be an order where the applicant was not properly represented for whatsoever reasons. Considering the above facts, this court is inclined to condone the delay of 250 days. Considering the above fact, this court is of opinion that the reasons shown by the applicant in this interlocutory applications may be regarded as sufficient reasons which prevented her to prefer the connected FAO within the period of limitation of how much? 90 days?
90 days.
90 days prescribed by the statute. In view of above, the delay of 250 days caused by the applicant in preferring the connected FAO is hereby condoned, and this application under Section 5 of the Limitation Act 1963 is allowed. Let the connected FAO be registered by the registry and list the same for admission after a week on a date to be fixed by registry.
You may kindly give a date.
No,
Date, my lord, how it will be fixed, my lord? It will be, it
Let
has
the
to be registered, my lord.
it has not yet.
I have not received a copy as of now. That is also one of the.
Okay.
Obliged, my lord.
That you remember?
May I please, your lord, please, my lord. May kindly come up after some time. My senior is on leg, lordship, he is on.
And more or less, I have concluded my submissions. I will just require 5 minutes or so to just put forth the concluding statements. my lord.
What IA is there?
It was listed on 20th of June. Last, it was listed on 20th of June. Wherein.
Now, what should we do? Should we wait for his counsel?
I will only
Time, lordship. We will be-
Okay.
Okay,
problem.
after some time we'll take it.
Please, madam.
Next item.
Much.
11. Have we heard it earlier?
Yes, Lordship, long time back, Lordship.
So I have forgotten everything. On when we heard it?
Last year,
13/2/2024. I must be.
in fact, I had completed my argument.
Now let me see whether I have notes or not.
Yes, Lordship.
Yes, Ms. Sharma has made some submissions. You can refresh and then start.
Yes, Lordship.
Yes.
Lordship, may I read the Ejaharda, Lordship? This is by the mother of the victim girl. Otherwise, Lordship, offense is a heinous because the girl is only 2.5 years old.
2.5 years
Yes,
old.
Lord.
What is the offense?
Offense, yeah, is POCSO under section 6.
Yes.
The plaintiff filed a suit for declaration right till the interest and so recovery of position. The suit was decreed against the present appellant filed an appeal. That was also dismissed.
Plaintiff suit was decreed.
Decreed.
Okay.
And the appellant filed an appeal. That was also dismissed.
Defendant filed an appeal.
Yes, my lord. Appellant was defendant number 1. Defendant number 1 filed an appeal.
How many defendants were there in the original suit?
In defendant, there are many defendants, but I am defendant number 1. Defendant number 1 and 2 originally, defendant number 1 and 2 filed written statement. Other defendants were not.
How many defendants were there?
There,
7 defendants.
7
defendants, my lord. Defendant number
7 defendant and defendant number 6.
7 performed.
7 is performer defendant. 6 and 7. 6, 7. And my lord, about those defendant number 1 and 2 contested the suit by filing written statement.
Okay.
And others were not filing written statement and not contested the suit. But one fact is, my lord, during pendency of the suit, the defendant number 2 expired. And defendant number 6 also expired. Who is the main person? He is said to be owner of the land. Were not, their legal representatives were not being substituted. Were not the defendant number 2 expired during the pendency of the suit. And defendant number 6 also expired during the pendency of the suit. But their legal representatives were not being substituted.
Suit was for declaration of right title and
Interest and
interest
recovery of position.
and recovery of possession.
And
The
also
suit
for
land
cancellation of sale deed.
cancellation of sale deed in favor of.
Defendant number 1, 2, 3, and 4.
There was a sale deed in favor of two, three, and one.
That sale is executed by the defendant number 6.
Okay, and in whose possession the suit land was?
In our position.
Our means
Defendant number 1.
defendant number 1,
One and
who has preferred the present second appeal.
Yes.
Okay. Now, the suit land is still in your possession.
in my position. It's still in my position. Now, what happened, my lord? So apparently, the decree passed against 2 dead persons. So ultimately, those were abated.
Suit abated against 6 and 7.
My lord?
Against 6 and 7.
Yes.
Against 2 and
2 and
6.
6.
2 and 6.
2 and 6.
Okay.
But only to that, my lord, the defendant number 2, 3, and 4, highly sweet. being title suit number 75/83
2, 3, and 4.
and 5. Hello suite being title suite number 75/1983. And in that suite, the present plaintiff, he was the performer defendant number 5.
Okay. This suit was in respect of what land? What,
That's it, is in this one, that part of the plan. Sample of it.
what is the suit land? Description of the suit land, how much land is there?
One kata 4 lechas.
1 katha,
4 lechas
four lechas. Where it is situated?
in Jorhat, Jorhat town.
Your town.
1 got 4 listeners. PP pattern number 268. Bag number 3617.
Okay.
Block number
This
1.
was the suit land in 75 of 83 also.
Yes.
Okay.
And in that suite, the performer defendant, the present plaintiff responded.
And the present suit which was decreed, what is the number?
The present suite is 177
177 of?
of 2000. It is the number, my lord. It was 77 1994. Originally, it was 58/87. Then it was again number 15/2007. Now what happened, my lord? In title suite number 75/83, it was renumbered as 66/1994. In that suite, my lord, plaintiff, present plaintiff, respondent was the performer defendant number 5.
Yes.
And the performer defendant number 5 filed written statement, contested suite, filed written statement as well as counterclaim.
Okay.
But that suite was dismissed. But counterclaim is remained as it is. It was no order was passed in the counterclaim.
Okay. Yes.
But instead of pursuing that counterclaim, it is a suite. Suite dismissed. Counterclaim is treated as a suite on their part. Without pursuing that matter, later on they file a suite, present suite.
This present suit.
Yeah, yes, present suite.
Okay.
So res judicata will be applied in that case. Section 11 of the res judicata.
How res judicata? It was not decided.
No, not
Their
decided.
suit was not decided.
No,
Not
let him
decided.
complete, I will come to it, madam. That was
That-
not a counterclaim, madam.
I am putting
All
questions.
right.
But that res judicata point has not been decided by the court below, both the court below. Now, the lordship will kindly see the res
No, no,
judicata-
in the instant case,
Yes,
in the instant, this title suit number
15/07.
15/07 has been decreed
Decree.
in favor of the respondents.
Respondents.
You preferred a first appeal.
First of all, it was also
Appeal
dismissed.
was dismissed. Against that dismissal,
come.
you are before this court.
While this appeal has
What
been
is,
admitted.
what are the substantial question of
Yes,
law?
your lordship kindly say, when this appeal was suspended, let's look at a point, your lordship kindly say substantial question of law. This court already formulated substantial question of law.
First question is whether in view of withdrawal of title suit number 30 of 1980, while a counterclaim remained on record, the subsequent suit of the plaintiff was barred. Now, listen, my lord, I have given a chart. In this case, these cases have been renumbered 2-3 times. Now on the top
66
left hand, yes, this
Now
30,
this 30 of 1980, which is that? case?
30 of 1980, your lordship, my lord, that was renumbered as this.
That you have not mentioned.
Down below, lordship, will see in this chart down below. This originally it was, my lord, this 16 of 1979. Then it was renumbered as 40 of 1980.
It was different, my lord. It
And
was different.
71 of 80 and 30 of 1980. And this counterclaim which my learned friend is talking about, that is 75 of
Yes, another
83.
suit, another suit.
This is, my lord, this perhaps while dictating this has been wrongly quoted, my lord. This counterclaim which my learned friend is
Okay,
submitting.
no, let him submit. first.
This one, no, I am correcting on this number, my lord. Otherwise, it will be confusion. This 30 of 1980, there was no counterclaim. This counterclaim
not
which he is submitting, that was in on the left hand side, 75 of 93, that is 66 of 94. So instead of
75 of 66 of
66,
94.
it's 75 of 83, that was renumbered as 66 of 94. So instead of 30 of 1980, it should be 66 of 94.
So the substantial question of law needs to be reformulated.
Yes, during course of hearing, lordship can reformulate.
No,
and-
but that is my query to you. Both are agreeing that this first substantial question of law mentions the wrong title suit.
Yes. But actually what happened, title suit 30 has been filed by respondent number 6.
That is
And that is different suit.
different suit.
And that suit
But
was
respondent number
withdrawn.
6,
He was also filed a suit.
but he died,
Died. That was also withdrawn.
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 So that is not the subject.
It's here.
So
Here,
thi-
66.
this substantial question of law is to be reformulated.
Reformulated.
Okay, this. How much time will you take, both of you? Remaining time, will it be?
It may be.
Possi-
Fix another, my lord, loss may formulate it, my lord. And next,
Will it
next
spill
week, next week,
Because he has to, I have to give a reply only. You will to submit.
No, will it remain part heard today or will you
I
be
think it
able
will
to?
remain part of my lord.
And don't
Submit
intend to
one
keep it part heard.
you just fix the date and.
No, if it is possible on your part to finish it,
Because
then I will
issue is small, my
reformulate
lord.
the issue today itself.
Yes, my
No,
lord.
no, you will also.
Or
formulate it.
otherwise, one part heard matter is in
Yes,
queue.
In queue,
Yes.
that is it.
I will hear that part heard matter.
Then my lord, next day, any day, it will fix, my lord. On that day, we will settle this one. In the meantime.
Then I will reformulate this
Yes,
issue
yes,
today
yes.
itself.
Yes, ma'am.
Heard Mr.
66.
J. Ahmed, learned counsel for the petition, learned counsel for the applicant. Appellant, sorry, learned counsel for the appellant. Also heard Mr. A. Das, A. Das, learned counsel for the respondents. Appellants are singular or there are many appellants?
Single.
Only, and respondent?
There is one.
One
And
is
one-
pro
one is
forma
pro
and
forma
only
defendant.
one contesting
There
respondent.
is
is one.
Respondent.
They are not contested also.
The both the counsel for the rival parties have pointed out that the substantial question of law framed by this court on 23/5/2014 needs to be reformulated as the title suit number, as the title suit number mentioned in substantial question of law number one within invert brackets is not correct. And both the councils have agreed that same may be reformulated. by incorporating correct title suit number, that is, what is the correct title suit number?
66/1994.
66/1994.
It was originally 75/1980.
1994. Okay, last line. No, title appeal number. No, say correct case number. 66 na lage likhi, no? Correct case number, start. Accordingly, after perusal of the materials available on record, the first substantial question of law framed by this court on 23/5/2014 is hereby modified as hereunder. Listen to it. huh?
Yes, sir.
Whether in view of, this was also withdrawal, in view of
Yes,
Yes. 30.
withdrawal of title suit number 75/1983, which was renumbered as title suit number 66/1994. While a counter claim filed by the present respondent
Plaintiff. Respondent plaintiff.
present respondent, what is the name?
Ram Nagina Gupta.
Namely Ram Nagina Gupta, remained on record, comma, the subsequent suit of the plaintiff was barred, question mark. Other will remain as it is.
Yes.
That 75 was not withdrawn, it was decided. 75, renumbered as title suit number 66, it was not withdrawn,
It
it
was
was decided
dismissed
on
on-
merit.
Dismissed on
dismissed.
29/3/2005.
And then it has to be again changed. It was not withdrawn.
No, it is
It was
dismissed
not.
on contest.
Ki likhe. No, withdrawal. In view of dismissal of,
Dismissal.
in view of dismissal of title suit for
In 1983.
to
Se-
no,
70
title suit number
75.
75 of 1983,
Renumbered as.
which was renumbered as title suit number 66 of 1994. Remained
Rem-
on record. Remain on record, comma. Bas. Now, let this appeal be listed again when?
30th, my lord. It was matter of 10 years old, my lord.
Yes.
Please,
I'm giving a date.
30th July, my lord.
8.5. 8.5.
30th is a hearing day.
Hearing day, my lord, Tuesday.
Okay, 30th July. Let this matter be listed again on 37/2024.
Hello.
Did you listen the photo medicine?
Please, Bharat. The matter was last listed on 20th of June, madam. So I more or less concluded my submissions. I will just take 5 minutes to conclude.
Just a minute.
Yes.
Yes.
Yes, at page 171, that is annexure 14, my lord. This is the order of taking cognizance under 420, 468, 471. The gamut of facts mainly revolve upon two tranches of share transfer. In my most respectful submission, one was done during the lifetime of late Shri Adilur Rahman. And the second chunk of 8,400 shares, my lord, which is also correlating and being corroborated through the ROC. That date is 7th of December, which is a date after the demise of the gentleman. So if my lord is pleased to see my complaint case, just to give a very short synopsis at page 143. Para 9 of my complaint. If I may.
Yes.
That it may be pertinent to mention here that late Shri Adilur Rahman, the husband of the accused number 1, died on 13 November 2012. The shares of the complainant were transferred in the name of accused 1 and 2 as follows. So this is a table. 5th January 2012, my lord. The transferee is Afroza Rahman. Number of shares transferred 218,100 shares. And the second tranche that was so transferred was on 7th of December 2012. So my lord will see, demise happened on 13 November. Right after that, on 7 December, the transfer takes place in the name of the transferee Azana Rahman, 8,400 shares. So if we look at the two documents that I say is a byproduct of forgery, that reflects a different date. And the date which is reflected in the ROC documents, which is a part of the statutory filing, the annual return of shareholding debtors, that talks about 7th of December. And this was so filed back in 2013-14.
Now,
So,
which ROC document?
So I had relied upon
No,
such.
but there is an objection raised by the petitioner counsel that ROC document is not was not filed at the time of.
Correct. I'll
It
address
was not
the
before the court.
Yes.
Which took the cognizance.
I have understood the objection.
So
My lord,
whether
that I will.
that can be taken into consideration at this.
So that's the last part of my submissions. First, I'll just give a short synopsis.
Yes.
For your lordship's consideration. So your lordship will see at this particular table, the second tranche happens after the demise. And now if I may draw my lord's attention to page 17. Two documents, 17 and 21 at page 17. This is the share transfer form.
Yes.
The share transfer form, the first tranche is at page 17. So if my lord sees the date of presentation, there's a seal at the top. It says 18/1/2012 and the approval date is at the end of the page, 5/1/2012. So on 5th January 2012, that is during the lifetime, although I'm disputing this document as well, but for the sake of arguments, I say that this approval date is 5th of January 2012 and the presentation date is 18th of January 2012. Then at page 21, the second tranche of 8,400 shares, my lord. So here there is no approval date, it's blank. But if I look at the middle part of the page, it says 5th January. So both the documents suggest that it was so drawn on 5th of January, 2012. And interestingly, this also has the presentation date as 18th of January at the top, the seal. So here the transferee is Azana Rahman. In the middle of the page, my lord will see there is a transferee column.
Yes.
It says Azana Rahman, occupation student, father's name Adilur Rahman, approval date is blank. So my respectful submission is that this date never existed. I say that this document is a byproduct of forgery. And why I say so, my lord, is upon taking reliance upon a public document, which I had so filed as a part of additional documents. Now, if I may be permitted to take my lord to the relevant pages. First is annual return for 2012-2013. It starts at 213. The reliance so made is 216. At page 216.
Yes.
Yes. So at 216, my lord will see that this is the filing that was done in 2012-2013 financial year. And this suggests that I, Dr. Nilufar Rahman, is still holding 8,400 shares. This is the second column of page 216.
Okay.
And then my lord will see 225. 225 forms a part of part 6. The part 6 of the annual return of shareholding is a part wherein, my lord, any transfer that has so happened in the preceding year is reflected in part 6. Here, interestingly, in the first bit itself, the first column at page 225, my lord will see date of registration 5/1/2012. Number of shares, debentures transferred 2,18,100. That is the first tranche. Transferor's name is Dr. Nilufar Rahman. Transferee's name is Afroza Rahman. So in my respectful submission, in 2012-2013, on 5th of January 2012, it so appears from the statutory records that 8,400 shares were still lying with me and 2,18,100 shares were transferred to the petitioner number 1, Afroza Rahman, who happens to be my sister-in-law.
What is the date of transfer shown in the share transfer form?
5th of January. This is correlating. I may be disputing the share transfer forms. I have maintained a clear stance that I have not signed any share transfer certificate. But the dates are correlating 5th January 2012, during the lifetime of my brother, late Shri Adilur Rahman, who happens to be the husband of petitioner number 1. But interestingly, my lord, 8,400 shares were still retained. And that will have a bearing at page 240. That is the next year's filing at page 240. This is statutory filing for year 2013-2014. At 240, my lord.
Yes.
Yes, the first column again. Date of registration 7/12/2012. 7th December 2012. Demise of my brother, November 2012. And here, the number of shares and debentures transferred, in our case, it will be shares, 8,400 shares. Transferor's name, Nilufar Rahman. Transferee's name, Azana Rahman, who is the beneficiary, my niece, who is the petitioner number 2.
Okay. Now, what do you want to show?
Yes, now coming to my complaints. So I just put a question to myself at page 140, annexure 12, my lord. that is this a date, 7 December 2012, something that I have introduced before the High Court at a belated stage. And this particular allegation of the transfer having been done on 7th of December was never put in my complaint. My lord will see the date of occurrence that I have so alleged in my complaint case at page 140. A date of occurrence, my lord will see 5th January, 7 December. This is the date that I am since alleging. So, my lord, in my respectful submission, this is not a new data that I have introduced. The ROC document is a public document which I will rely upon a judgment of the court. But before that, my lord will see that I have made a specific allegation that the transfer was done on 7 December. So 7 December in my respectful submission is not a date that I've introduced at this stage. I might not have relied upon the ROC documents at the time of the learned trial court taking cognizance. The learned trial court, basis the documents on record, has taken cognizance of the matter under 420, 468, 471. But is it a case that I had never alleged a transfer having been done unlawfully, arbitrarily on 7 December? My lord will see the complaint. At page 140, date of occurrence is 7/12. And similarly at para 9, the table that I started my arguments with, para 9, 143, my lord, the table suggests that the second tranche happened on 7th of December. The demise happened on 13th of November.
Now, what happened on 7/12?
7/12 is the document at page 240 that I had since relied upon. That transfer, my lord will see page 240 for my satisfaction. 240. I just relied upon 240. That is forming a part of the additional document.
No, that's statutory
Compliance.
compliance. Has
Which
been-
in my respectful submission is a document, if not recalled, has attained finality. At 240, again, I'll burden the court. The date of registration of these shares is 7th of December, which is the allegation in my complaint case. If I look at the
in favor of Azana.
in favor of petition number 2,
Azana is the daughter.
is a niece. Yes. Niece of the complainant.
Okay.
The daughter of
Afroza.
Afroza Rehman. That is the petition number 1. At 241, just to show the signatory to the annual return, at 241, my lord will see Afroza Rehman, director, and one Sajid Haq, director.
Just a minute. 240.
240, and then 241 is the last page reflecting the signatories to the annual returns.
Okay. Now, what do you want to say?
I want to say, my lord, that it might not be wholly correct that both the transfers, the first lot of 2,18,100
Had happened
and
during the
8 lakh
lifetime.
had happened during the lifetime, which was the first leg of arguments, that everything had happened during the lifetime, and as such the beneficiaries cannot be now drawn into this collusive action.
Okay.
And then the second argument that I have to make, my lord, is to satisfy this honorable court regarding the ROC documents, the annual return of shareholding. I am just relying on a judgment of the Honorable Supreme Court. My lord is pleased to bear with me. I'll just give a copy. Citation further. Okay. Although the factual matrix might be different. In this case, the argument had come from the petitioner in a quashing matter concerning NI Act. But I will only rely on the fundamentals regarding annual returns, whether it forms a part of documents falling upon the realm of public documents. If my lord is pleased to see para 8 of the judgment, this is Anita Malhotra versus Apparel Export Promotion Council and another. This is Honorable Supreme Court. At para 8, first I'll just highlight the arguments from the council and thereafter the observation of the court. At para 8. This is internal page number 7, if my lord has.
Yes.
Mr. So-and-so, learned counsel for the appellant, by drawing our attention to a certified copy of annual return of the company filed with the Registrar of Companies, which was placed on record before the High Court, contended that it is a public document in terms of 74(2) of the Indian Evidence Act, and the High Court ought to have accepted the same as a valid document and quashed the criminal proceedings insofar as the appellant is concerned. The High Court, in the impugn order, after recording the statement of the counsel for the petitioner therein, that Form 32 is not available in the record of the Registrar of Companies. Form 32 is regarding the directorship. And finding that Form 32 is the only authentic document, an annual return dated so-and-so filed by the accused company is not a public document, rejected the claim of the appellant and dismissed the petition filed for quashing of the complaint. So in this case, my lord, reliance was played by the accused in relation to the annual returns of the company, but the Honorable High Court had taken a contrary view, and hence the matter came before the Honorable Supreme Court. Now, my lord will permit me to read para 10 at page 9, internal page number 9. Mr. So-and-so, by taking us to the relevant provisions of the Companies Act 1956, particularly sections 159, 163, and 610, subclause 3, contended that the annual return dated so-and-so is a public document and the same is reliable and legally acceptable, insofar as the contents of the same are concerned. So this is still forming a part of the allegation of the contentions. And then it highlights section 159. This annual return to be made by the company having a share capital. Every company having a share capital shall, within 60 days from the day on which each of the annual general meetings referred to in section 166 is held, prepare and file with the registrar a return containing the particulars specified in part 1 of schedule 5.
That is not the question.
No, I know. I'm just coming to that. I'm just coming to that, my lord. So these are the 3 sections, how annual returns are to be maintained and kept for inspection. Then at para 11 is where the finding is. At para 11. Para 11, a reading of the above provisions makes it clear that there is a statutory requirement under 159 of the Companies Act that every company having a share capital shall have to file with the Registrar of Companies an annual return which includes details of the existing directors. The provisions of the Companies Act require annual return to be made available by a company for inspection, as well as so-and-so which entitles any person to inspect documents kept by the Registrar of Companies. The High Court committed an error in ignoring Section 74 of Indian Evidence Act. Subsection 1 of 74 refers to a public document, and subsection 2 provides that public documents include public records kept in any state of private documents. A conjoint reading of 159, 163, and 1610 subclause 3 of the Companies Act, read with subsection 2 of 74 of the Evidence Act, make it clear that a certified copy of annual return is a public document, and contrary conclusion arrived at by the High Court cannot be sustained. So in my respectful submission, I am placing reliance on the annual return of shareholding, which according to this particular judgment and with the limited knowledge that I so have, is a public document available in the public realm. So there is no question of today having any dual observation in relation to the authenticity or the veracity of the document. And such a document can be placed before any forum for its fair appreciation, my lord. I am not trying to improve my case, which in my respectful submission, I say that 7 December 2012 is not a date that I'm introducing at this stage through the ROC. I will get a million opportunities before the learned trial court to use this document in the manner, the various parts of trial which I can, however, put this document. But today, my lord, that is for the trial. Today, the question is, am I introducing a new angle, a new case to sustain the complaint that I had so made before the learned trial court, basis which cognizance was so taken. 712 was not a new fact, my lord. 712 is now getting reaffirmed. 712 is getting reaffirmed that even in the statutory documents that were signed by the petitioner and having not been recalled till date, cannot have any dual interpretation. And if it is a document in public domain, very well it can be taken reliance upon. Today,
what
yes.
is your submission regarding the fact that the share transfer form at page 21 was presented on 5th of January?
But that will have no bearing because share transfer certificate is a certificate that is executed for internal purposes. All of that may be attached
No,
to
but
annual. Yes,
those are the documents you have annexed along with your complaint.
that is a document that I have annexed because no, that particular document, if my lord may see the complaint case again. Naturally, my lord, this document could not have been in my possession.
This ROC return, you want to rely only to counter the submission of that the transfer was effected after the death of the,
Precisely,
to bring that point.
precisely.
Okay.
Because in my respectful submission, that date is just getting reaffirmed, my lord, through the ROC documents. The date of 7/12 is a date that is forming a part of my complaint. So it is a matter of fact, which I am saying that the entire gamut of facts reflect the transfer of two tranches of shareholding. One during the lifetime of late Shri Adilur Rahman and one after his demise. And if any transfer has happened after his demise, so it might not be the correct premise to suggest that the petitioners have no role. And whether they have a role or not is something that will have to be tried.
No, but
To seek exoneration at
dur-
this stage.
no, during your, there have to be specific accusation against them.
Yes, my lord, at page.
During your examination under section 202 and 200,
Yes.
you have not made specific allegation.
I have definitely made the allegation that 8,400 shares were transferred subsequently. That is the consist. Last time my colleague had read that particular portion of the statements. The statement to trial court statement. My lord, my case is consistent. The case of the respondent is consistent. That this is a company which was mainly held by family members. I am a doctor by profession, so I was not involved in the day-to-day affairs of the company. But that in no way will mean that my shares is of less value. I had given the entire authority to my brother and his family members, but that authority was vitiated. That trust was vitiated. And all of these transfers were done behind my back. Only later, after my brother's demise, my lord, interestingly in 2014, 2 years after the demise of my brother, a succession petition was filed by the petitioners, claiming themselves to be the successors, wherein I had been arrayed as a necessary party. That is when I got to know of these shares having been transferred illicitly. And these particular allegations I raised through letters, communications, which on the last date of hearing I had relied upon. There were 4 rounds of exchanges wherein my stance is consistent. That I have got to know of all of this. You are my family member. Please alter the position. But then a response had come from the petitioner saying that I have no idea all of these things were done during your brother's lifetime. And that is when the due diligence was done. And that is when we got to know of all of this. Constraining us thereafter, my lord, to come before the court and file the 200 complaints. So my only small submission is the date of 7/12/2012 might be reflected in the ROC document, which I say is a public document. Reliance can be placed at any stage. But this date is not a new introduction. In no way I'm trying to improve my case. This is my small, humble submission. This is a date which is being reflected in my complaint. And today the cognizance has been taken on a prima facie appreciation. I will get chances in trial. In my respectful submission, I say so. To prove my case. But this is the only humble submission.
My lord, some of the facts I just will try to clarify your lordship. First of all, this is a case of cognizance of taken 420 and forgery, 416. Now, transfer of share is one thing, my lord. It may not be the criminal act, my lord. The criminal act is the forgery.
Yes.
Transfer of share ipso facto does not create any offense, my lord. Now, what is their cases, my lord? Their case is that there is a transfer of shares. Let us forget about the date, my lord. I'll come to that effect, my lord. But for transfer of shares, my lord, there is a forgery committed. He has not signed, she has not signed any document. But the forgery was committed, transfer of share has been made. For the transfer of shares, the primary requirement is that there must be some forgery of document. Now, which document been forged, my lord?
17 and 21.
No. There is no such
There is no
document.
mention.
No advertisement in the complaint petition that this particular document has been forged, by which the transfer has been made. Because and that there is no advertisement in the complaint petition that signature, my signature in these two documents or in this particular document has been forged, and accordingly by virtue of this document, transfer has been made.
Okay.
There in the complaint petition, there is no advertisement by which document transfer has been made. The share transfer, madam. Absolutely silence. They are simply saying that the transfer was made forging my document. But we need a primary document, my lord. They have to avert that this is the document, by virtue of this document, share has been transferred, my signature has been forged in this particular document, though I have not signed. Which that document? Whether they have exhibited that document, whether they have marked that document, or whether they have called for that particular document. Absolutely nothing. What the lordship kindly see, the complaint petition 140 it starts. Now the paragraph 9 simply, my lord. All the paragraph simply they says the accused has transferred the shares illegally, forced. But the which document they have transferred, my? Now, paragraph 9 is it is pertinent to mention herein that late Adilur Rahman, husband of the accused number 1, died on 13/11/12. The shares of the complaints was transferred in the name of accused and 2 as follows: 5/1/12 in the name of Afroja. Then on 7/12/12, Arjana. So this has been transferred. Okay. Now 10.
The complaint begs to say accused number 1 with an intention to hide the scene of falsification of forgery has been shown the name of Adilur Rahman for transfer of share in her name. The fact remained that the shares were transferred in the name of accused person. So the accused person are the guilty of the said illegal transfer of the shares and doing forged the forgery of the signature of the complaint. In which document, my lord? Besides so and so, they have not said that the document that has been annexed, that these are the document where our signature has been forged, man. Am I clear, man? So what is the primary requirement? Now, that is one part. Now, if we go by this complaint petition, my lord, his case is that one part of the share is transferred. Now, the application for the transfer and the transfer of the share is two different things, man. As per as the public document, which he is relying on. What is the public document, my lord? These are the two public documents for, let's for the argument's sake, that these are the two documents, lordship kindly see page 17. These are also public documents, and he now is saying that he is not accepting these two documents. He's disputing this document. If he disputing these two documents, my lord, his own argument, my lord, can you see? He's argued before this court that he is disputing the authenticity of 17 and 21. If shares not being transferred by these two documents, then by which document share has been transferred? They have to avert it. That this is my signature, by virtue of these documents, the share has been transferred. But in the complaint petition, they have specifically stated two dates, that is the 5/1/12 and 7/12. Now, lordship kindly see these two documents, 17, it was presented, it was prepared on 5/1/12. Presented on 18/1/12. Next one also dated is the 5 January, my lord. 5 January 12. Again presented in the 18 January 12, prior to the date of my husband. Both the document. Our case is
then if
these document, my lord, these two documents shows that these two documents were prepared prior to the date of the complainant's brother. He died on 13/11/2012. And these documents both are presented on 18/1/2012, man. Both document, man. These are the two share transfer form. If they dispute these two documents, my lord, there is no other document. They have relied where the forgery has been committed, man. Am I clear, man?
What is the date of registration?
No, our case, our case from the complaint petition itself, my lord. I'm not going beyond the complaint petition. Their own case is that one, they have admitted that one is prior to the date. Because they can't say, because the date itself is very clear. One is on 5th. The complaint petition, you can list date 5th and 7th.
143, sir.
143, paragraph 9. First one is 5/1/2012. That is prior to the dates. And second one is 7/12. So
No, no.
second was,
No,
as far as them, second was is being transferred subsequent to the death. One they have admitted, this is prior to the death.
No, I just want to understand one thing. The share transfer form.
Yes, that was presented.
Of Azana
Yes,
was presented on 18/1/2000.
both are on 18 man.
Then
Both
how,
are not transferred because one, she was not present. So the transfer could not take place at that relevant time. It was transferred subsequently. That was the actual fact, man. She was not present. On her behalf, the lordship can see that it was signed by the father itself, late father itself. Lordship can see from the transfer certificate itself. As she was in the abroad at that time, for Ajana, the father himself signed. Page 21, my lord.
yes. So it was registered later on after.
Yes. After she came back, it was subsequently been transferred. That is, their case is then now the transfer has been subsequently been, but it was presented. That is more important. The presentation for the transfer of the share. Who did it, my lord? The process of initiation, who did it, my lord?
No, what is this concept? Presentation and registration. These are two different.
Yes, my lord, who has the document? This is the case of a forgery, my lord. That forged, the purported forgery, if this is the, if they dispute this document, I have nothing to say, my lord. If they say, no, this is not the document by virtue of which the share has been transferred, then I have no, I will not argue this case, my lord.
No, they are saying that by this
If this
documents, the transfer has been made.
If this by
but
this document, the transfer has been made, my lord.
But the signature of Nilofer is.
Yes. So, but when it was placed, my lord, before the authority, my lord.
During the lifetime of
During
the
the
brother.
lifetime of the
Father of the
brother of the complainant, my lord. It was on 18. At that time, he was alive. It was admitted fact, my lord. Both the document has been placed at the lifetime, during the lifetime of the complainant's own brother. This is not a case that there is no avertment, my lord, that this document was prepared subsequently to the death of the brother, my lord. There has to be some avertment to that effect, that this document was prepared subsequent to the death of the brother, but they himself admitted by that the share has been, the first one, the share has been transferred on on fifth one itself. The paragraph 9. Paragraph 9 is very specific, my lord. Their own case, their own admission that the shares got transferred on 5/11/12. At that time, he was alive. Only the second one, it was transferred subsequent to his death. But the fact remains that these two documents, the share transfer form, it was presented before the authority during the lifetime of the brother of the complainant. So who did the forgery, my lord? Is there any avertment to that effect that we did the forgery either during the lifetime of this brother or the subsequent his death? It can't be, my lord, because he has presented at that time. So next is that there cannot be two stand, my lord. They can't take a two stand. We have to go by simply by the complaint petition and the evidence recorded during the process, my lord. Now, if they dispute these two documents, my lord, as he has, my lord, my friend has disputed this document today. the authenticity of the, if this is disputed, my lord, then by virtue of which document share got transferred, my lord? There's no such document at all. Along with the complaint petition. No avertment by virtue of these forgery. There has to be one primary document where the forgery has been committed. That is the primary burden of the complainant to establish the fact that this is the document. In this document, my signature has been forged, and by virtue of the forging my signature, the share got transferred. So that document does not exist. Now, Lordship kindly see, now they are saying that the share got transferred after the death of the, now the what is their case? Now, how can he is explaining contrary to what is the complainant has stated? How he can explain what is the complainant has stated before the court under the oath? Now, what complainant stated, my lord? The complainant categorically stated that in the deposition that I am reading again,
Which
the deposition, my lord, in the, my lord, Lordship will find it in the LCR, my lord. The LCR to read your mark. Very important, my lord. I'll go to the all LCRs, my lord. The deposition, my lord. The during the statement under 200 and the evidence before the charge. Both are important. What she has deposed, my lord. Because once the evidence started, whatever the complaint petition, that's not a very important one. The evidence is more important than the complaint. Because evidence is under the oath, not the complaint petition, my lord. This is, my lord, Lordship kindly see. As your Lordship got the deposition.
yes.
The initial statement, my lord. That is recorded on 4/9/2015, my lord. Initial deposition.
Yes.
Under Mur Gusor so-and-so. Moi Hotel Dynasty Director Asilu, Mur Namot so-and-so Toka shares Asil, Mur Dada, late Atikur Roman Hotel or FI Saisile. Moi Bisakot Hokolu Daito Town did Isilu. That's very important. Jua Tero Egaro Barot, Mur Dada Dhukai. Mur sister-in-law Jetia succession certificate apply kore tetia moi hotel share etc kotha janibole register of companies or statement lolu tetia gom palu je mur namot iman shares mur dada dhukuar agote that you can see very important mur dada dhukua agote mur sister-in-law Afsuja Ramana namot transfer hoi jay. Now, how can there be a different interpretation that after the death of the brother, share got transferred?
No, he is saying after the death only in case of Azana.
Yes, I'll come to
On
that.
this, on the
That is his submission, my lord, but this is contrary to the, I'll come. But if the Ajana also, the one factor is there, then the Ajana is liable. Then also one factor is that who has placed those documents? Is this document was placed after the death or before the death? Admittedly, it was before the death for the transfer. Ajana was nowhere in the picture at that time. Director was the father, managing director. Complainant is the one of the director. How Ajana created the forgery, my lord? Where is that avertment, my lord? Now, so shares got transferred. The one next one is so here in the initial deposition, as your lordship has rightly pointed out, that where is that avertment that the who did the forgery? In the initial deposition, there is no such a whisper regarding the forgery of the document. Simply they are saying that the share got transferred from so and so to so and so. মোৰ নিশ্চয় নামত ট্ৰান্সফাৰ আৰু কৈছে দেন দি বেলেন্স shares মোৰ দাদা ঢুকুৱাৰ within 3 weeks ভিতৰত মোৰ নিশ্চয় নামত ট্ৰান্সফাৰ হৈ যায়. So within 3 weeks the share has been got transferred in the name of her niece. But it's not a case.
Whether any civil suit is pending between the parties.
Yes, party pending.
Pertaining to these shares.
Yes.
These
Apart
shares.
from the others,
There are 21 litigations going on.
including the shares.
These shares
Yes,
are
it's
also
also
subject.
subject matter of the company petition, my lord. Essentially, all of this is forming a part
Say
of the challenge.
directly that yes, this is the share is also a, why you are taking the other route?
The criminality will not be
That's
written
a
off.
difference. The
Yes.
court has questioned whether
Yes.
this, regarding this share, any case is pending civil suit.
Okay,
Yes or no?
okay. Yes.
Now, here in the initial deposition, not a whisper against Ajana. That she somehow involved in the share transfer.
Okay.
Nowhere even the name does not appear at all. Next one, Lordship will kindly see CW2. She also admitted that, my lord, the complaint Nilufar Moor Swali hoy so and so, Ajana Rahman opor dise, Afroja Moor Buhari, Ajana Moor Natini hoy, Moor Dangolor Adilu Rahman namot, Nilufar namot Rahman properties then asil, Nilufar namot 2,26,500 shares asile, a share khini Adilure. Now this is lordship very important. Who has transferred it, my lord? Very categorical statement. Adilure transfer ঢুকুৱাৰ আগতে Ajanar নামত transfer কৰি দিয়ে. Who has transferred it? In the name of Afroja. Adilur. If Adilur has transferred the shares, then how we are involved, my lord? It is the Adilur, it is their case, my lord. How he can now interpret? It is won by the Adilur who has transferred the share in the name of his wife. So apparently, both the shares being transferred by Adilur itself. Now, Lordship kindly turn the deposition before the charge. Now, PW1 is the Nilufar Rahman. Deposition lordship will be filed in the LCR itself. Must be in the LCR. Evidence before charge.
Yes.
It was on 4/4/16, madam.
Yes.
Now, মই আসামিগণক চিনি পাওঁ আফরোজা রহমান মোৰ বৌ হয় and আজানা মোৰ নাতিনী হয় ৰেহমান প্ৰপাৰ্টিজৰ 226,500 shares মোৰ নামত আছিলে মোৰ ব্ৰাদাৰ আদিলুৰ ৰহমানে যোৱা ইমান তাৰিখে ডেট হয় আৰু সেইখিনি পিছত মোৰ বৌ আফৰোজাৰ সাকসেছন বিচৰা বুলি নটিচ আহে আমি তেতিয়া shares উলিওৱাত গম পালো যে মোৰ নামত থকা ইমান shares আফৰোজা নামত আৰু বাকি শ্বেয়াৰবোৰ মোৰ ব্ৰাদাৰ ঢুকুৱাৰ কেইদিনমান পিছত আজানাৰ নামত ট্ৰান্সফাৰ কৰে মই তেতিয়া সকলো জনাই মোৰ বৌ আফৰোজাৰ লেটাৰ সেন্ড কৰো মই জনাও যে মোৰ শ্বেয়াৰবোৰ মোৰ নামত ট্ৰান্সফাৰ কৰিব লাগে মই 6-7 মাহৰ ভিতৰত দুটা চিঠি দি এমিকেবল সেটেলমেন্টৰ কাৰণে ট্ৰাই কৰো আফৰোজা ৰহমানে মোক ৰিপ্লাইত জনালে যে শ্বেয়াৰ সাৰ্টিফিকেট ট্ৰান্সফাৰ হোৱাটো সঁচা আৰু মোৰ ব্ৰাদাৰ আদিলুৰ ৰহমান জিয়াই থাকোতে হোৱা বুলি কয় কিন্তু বেলেন্স এমাউন্ট ট্ৰান্সফাৰ কৰা কথালৈ তেওঁ কোনো কথা নকয় তেওঁ ৰিপ্লাইত লেটাৰত লিখিছিল মই কোৱা কথাবোৰ বেসলেস বুলি এমিকেবল সেটেলমেন্ট নকৰো বুলি কয় তাৰ পিছতে মই ফলসিফিকেশন সিগনেচাৰ ফৰ্জাৰীৰ বাবে এই কেছ ফাইল কৰো ৰহমান প্ৰপাৰ্টিজ লিমিটেড এনচেষ্ট্ৰেল প্ৰপাৰ্টি হয় আসামে মোৰ নলেজ নোহোৱাকৈ শ্বেয়াৰ ট্ৰান্সফাৰ কৰে ইমান লেটাৰ নাও লৰ্ডশিপ kindly see exhibits this is very important. Now, Lordship, kindly see the exhibits. He has in the deposition itself. Exhibit 1 is the letter dated 2/12/14. First one, my lord. Has your lordship got it?
Yes.
Exhibit 1 is the letter issued by me to accused. Here, that is exhibit 1 letter. Exhibit 1 by my signature. Reply to exhibit 2 is the reply of the accused Afsara Norman on 16/12/14. Exhibit 2/2 is the signature of the Afsara 2. Exhibit 3 is the second reply to my letter. Exhibit 3 dated so and so, exhibit so and so. On 14/14, Afruza Rahman sent me another letter. Exhibit 4 is the letter. Exhibit 4.1 is the signature of Afruza Rahman letter dated so and so. Annexer Properties Limited. I have submitted the blank so and so papers with the signature of my brother during the stay of the Bangalore. So reserve, cross reserve. So where is that forged document, my lord? Where her signature has been falsified and the shares got transferred. Neither in the deposition, my lord. This is an evidence before charge, my lord. So we have come at that stage, my lord. So the evidence before charge is very categorical. Now the whatever the avertment in the complaint petition, that's a different issue. Now we have to stick to the evidence itself. Now the evidence, does it there any avertment to that effect that the accused petitioners, my lord, somehow connected for the forgery? And if so, which document they have forged? There's no exhibit at charge. Not a single document by which they can show that by these document, my signature has been forged and the share got transferred.
Okay.
So without averting to that effect, the PW2 also same, my lord.
Your submission is on the basis of this cognizance should not be have.
No,
should
my
not
lord, the cognizance as well as we have come after the evidence before charge. This is a warrant procedural case, my lord.
But your prayer is for quashing of the complaint.
Yes. So on the basis of these, my lord, there cannot be any complaint. So there has to be some evidence, my lord, material evidence to frame charge also. Even if we don't go by these, but these will remain forever, my lord. The evidence before charge. They have not exhibited a single document, the evidence before charge. Which document they have relied regarding forgery? Neither in the complaint petition, my lord. And now the document, these two documents they are disputing. The authenticity of the document in page 17 and 19. 20. Now, the page 152A, my lord, they have exhibited that document, my lord, during, yes. They have exhibited that document, my lord. They have relied on that document. My reply. This is their case, my lord. My reply. This is the, my lord, her own letter, my lord, second letter. The second letter just which has been exhibited during the evidence, my lord. The point number D in page 152, capital A, my lord. My shares in Rahman Properties have been transferred illegally by falsifying my signature. You have mentioned in the letter to me that the shares were transferred during my late brother Adilur Rahman 10 years of Swenson Company. It may be so, but it still does not make a share transfer legal. So she herself agreed to that fact. The transfer has happened. But whatever, my lord, the one fact is clear from the deposition of that the Adilur, the CW2, their own state witness has said that the Adilur transferred the share to us, my lord. We have no role. There is no conspiracy charge, my lord. No avertment to that conspiracy is there. So to that effect, my lord, so that's my case now. As far as the complaint petition is concerned and the initial deposition, there is no document as such where the forgery been committed, my lord. They are silent. Absolutely. Subsequently, in the deposition before charge, they have exhibited 5 documents, not a single document where the forgery been committed. In the initial deposition as well as the deposition before the charge, my lord, there is no avertment that how we have been implicated, what role we have exactly been played. Even in the 202 deposition also, Ajana's name is absolutely not there, man.
Okay.
So how we are involved, my lord, that has to be satisfied, my lord. And their case is that the share is transferred subsequently, one part, the 8,200 shares. Maybe, my lord. But it was presented, those document was presented by Adilur itself. That is their own CW2. That cannot be changed, my lord. There cannot be any another interpretation to that effect, my lord. What the deposition, the PW1, the CW1 and CW complainant himself said, that the Adilur has transferred before to his death regarding first part of the share. And the second part, the CW said that the Adilur did it. Not by these 2 petitioners.
One
If-
query, I have one query to Mr.
Yes.
Das. Mr. Das.
Yes, please, ma'am.
This, where in your complaint petition, you have mentioned that offense is under forgery 468, 467, 471, using a forged document. Have you specified as pointed out by the counsel for the which document has been forged, how forgery was committed? Apart from mentioning the offense that forgery has been committed, how it has been committed, who committed,
Please.
what was forged, whether this is required or not for taking cognizance.
At the stage of the complaint, my lord, if I may draw my lord's attention to the same document at 140.
Yes.
This is my complaint case.
Where have you-
Allegation 420, 467, 468, 471.
Yes, that you have
yes.
mentioned.
Then I have included the dates. But again, coming to my lord's question. Per se, this particular document.
Because this is a complaint case.
Yes.
For taking cognizance and for proceeding with the criminal trial, some materials have to be there.
Precisely.
So what are those materials? Even accusation has to be there, specific accusation.
If my lord permits me to read the deposition of Atikur Rahman.
Yes, he has read already.
No, Atikur Rahman is the brother, So I will, if I may permit it to just read.
PW? That is initial deposition or evidence before charge.
Initial deposition, my lord. My lord, may I read?
Just a minute.
Dated 21 niki?
21.
Right, sir. Anyone?
Okay, CW1, yes, read, please read.
Complainant Nilufar Rahman মোৰ ডাঙৰ বাইদেউ হয়। তেখেতে আফৰোজা ৰহমান আৰু আজানা ৰহমানৰ ওপৰত এই গোচৰ দিছে। মোৰ বাইদেউ ৰহমান প্ৰপাৰ্টিজত 2,18,000 শ্বেয়াৰ্ছ আছিল। মোৰ দাদা লেট আদিলুৰ ৰহমানে সকলো বিজনেছ চোৱা চিতা কৰিছিল আৰু সেয়ে মই আৰু বায়ে তেওঁক বিশ্বাস কৰি কেতিয়াও শ্বেয়াৰ্ছ এক্সেট্ৰা চেক কৰা নাছিল। কিন্তু ৰিচেণ্টলি গম পালো যে বাৰ শ্বেয়াৰ্ছবোৰ 2012 ট্ৰান্সফাৰ কৰে আৰু মোৰ দাদা ঢুকুৱাৰ 45 ডেইজৰ ভিতৰত লাষ্ট 8,400 শ্বেয়াৰ্ছো ট্ৰান্সফাৰ কৰে আজানা ৰহমানৰ তাত। কিন্তু এই বিষয়ে আমি পিছত গম পালো। আমাৰ কোম্পানীৰ CA থ্ৰু দি এই বিষয়ে গম পাইছো। কিন্তু মোৰ বা নীলুফাৰ ৰহমানে কোনো কনচেণ্ট দিয়া নাছিল। সেইকাৰণে আমি গম পালো যে বাইদেউৰ চিগনেচাৰ ফৰ্মবোৰত টেলি কৰা নাই। আমি মিউচুৱেলি সেটেল কৰিব ট্ৰাই কৰো, কিন্তু তেওঁলোকে একো ভুল কৰা নাই বুলি কৈ থাকিল। শেষত বাইদেৱে এই কেছটো দিছে।
This was the premise basis which the complaint was lodged after 2 years from the demise of late Shri Adilur Rahman, my lord. So the consistency from the side of the complainant
Where it was not telling.
it was not telling him potatoes transfer to
See,
with the folio numbers.
no, that
In the last part of the
signature form board tally kora nai. Where? Which form you are referring to? How the magistrate will know?
No,
How
it-
the court will know?
Naturally, it will
Unless
be
the
share
accusation
transfer.
is
Naturally, it will be the share
Yes.
transfer forms, the share transfer certificate
No,
at
that
17 and
is
21. That's the only document.
Somebody has to accuse that you committed forgery in respect of this document. And you continue to use this document in spite of knowing the fact that it is a forged document.
Yes.
Then only 471 will come.
Precisely.
Therefore, the burden, whether burden lies on the complainant to point out which document has been forged. This CW one, CW1 Atikur Rahman only mentions that signature does not tally. Signature of Nilofar Rahman does not tally.
Yes. In the forms. The form, so that is naturally the share transfer certificate forms. There's nothing, there's no other forms.
But Nilofar does not say that these are not my signatures.
Why not? She says at
Where?
page, she most definitely she says
Where?
at page 143. At page 143 of my complaint, right underneath the table, para 10. My lord has it. After highlighting the dates 5/1 and 7/12, at para 10 I say that the complainant begs to state that accused number 1, with an intention to hide her sin of falsification of forgery, has been showing the name of Adilur Rahman for transfer of shares in her name. But the fact remains that the shares were transferred in the names of accused persons. So they are the beneficiaries. So the accused persons are guilty for the said illegal transfer of the shares and for doing forgery, I believe, of the signatures of the complainant. Besides that, 8,400 number of shares were admittedly transferred after the death of Adilur Rahman. So for the said transfer, the accused persons have no space for their explanation. So it means no space for the explanation. That the complainant begs to state that the accused persons did the wrongs with studied mind and guilty intention and have committed forgery by transferring the shares of the complainant and also for wrongful gain for such transfer. The accused have invited the consequence of offense punishable under 420, 467, 468, 471. So I am saying, and even in my initial deposition, if my lord permits me to read just one part of Nilufar Rahman.
Nilufar Rahman dated 4/9/2015.
What she says?
In the second page, in the last second line.
Yes, second page. And this is the
Yes,
second-
please read.
মোৰ কনচেন্ট নোহোৱাকৈ শ্বেয়াৰ ট্ৰান্সফাৰ কৰিছে কোনো পেপাৰতে চাইন কৰা নাই মই মোৰ দাদাক কেইখনমান ব্লেংক পেপাৰ চাইন কৰি দিছিলো
That is brother,
Where is
which
the-
document, my lord?
read.
in the initial deposition
Yes,
Okay.
Just read the last two
Okay.
lines, sir. Where are you?
মোৰ কনচেন্ট নোহোৱাকৈ শ্বেয়াৰ ট্ৰান্সফাৰ কৰিছে কোনো পেপাৰতে চাইন কৰা নাই মই মোৰ দাদাক কেইখনমান ব্লেংক পেপাৰত চাইন কৰি
which
দিছিলো
document, my lord?
কাৰণ তেওঁ লোন আৰু হোটেল ৰেনোভেট কৰাৰ কাৰণেই সেইটো লাগে
Which
বুলি
document?
কয় মই বিশ্বাসত চহী কৰি দিম
That I have read, my lord, but which, my case is that which document, my lord? That share goes transfer, which, where the forgery been committed, my lord? Who makes the false document, my lord? That is the forgery, my lord.
Nilofer is saying that she has given her signatures, but on blank.
Blank paper.
Blank sign.
letter.
She is not saying that this is not my signature.
Yes.
All of these documents, my
So
lord
is
will
that-
appreciate, my lord will appreciate after my learned colleague says, I'll just 2 minutes, take 2 minutes. My lord, share transfer forms are internal documents. It may or it may not be presented with annual returns. This is a
That's a
fact
big-
finding. I have done my due diligence to assist the court. Share transfer certificate is for your internal bookkeeping.
No, that is not my query.
I
Query is,
understand. I understand.
Where is the document, my lord? That is what I am also trying to.
I'll come to you.
Yes, my lord. Which document? Probably that is the
When you
question.
are alleging forgery before a court against a person, whether or not you have to point out which document has been forged and in what manner it has been forged,
This document was not.
or whether a
Yes.
general statement that forgery has been committed is enough.
My lord, naturally, if this document was not exhibited, that means at the time of preferring the complaint, this particular document was not in my possession. Naturally,
There's no,
naturally,
there's no two
this
department.
document, this document has
Where is that-
surfaced.
Where is that department, my lord? Where
Otherwise,
is
there
that
is,
department that
otherwise,
this document does not?
Okay.
If this document is not with him,
Okay.
how she came to know that the
I-
forgery been committed on that particular document?
Okay, I intervene by putting a query.
please,
You have answered that query.
yes.
My query was how the complainant has shown in his complaint as well as in his initial deposition as well as evidence before charge that forgery has been committed. You have answered that.
Yes, by virtue of that particular part of the
Okay.
deposition.
Now, how much time?
Yeah, but that has to be, well, that's my submission is over, my lord.
Okay.
Because that has to be read along with the CW, my lord, 3, my lord. That has to be conjointly read, my lord. The CW,
Nilofer.
not my lord, Nilofer is the
CW3 is
CW1, my,
CW.
sorry, my lord.
CW1 is Atikur.
Yes. The mother, Romena,
Romena. Okay.
CW2. Now, they have read before the Lordship in CW1, Atikur. Atikur said that by their signature form would telekoranai. Okay, very good. Signature in the form. But they said, my lord, we don't know. At the time, we may not have that, we don't have that document. That's what we can't say in which document. Then where is the case? We say at the time of filing of the complaint, we didn't have that document where the forgery been committed. Then how they came to know that the forgery been committed at all? They specifically, then if we go by the CW1 and CW2, what the case is that the CW2 closes everything, my lord. Our statement is very clear that the A share kini adilure dhukwar agote transfer
She
kori
is
goise.
accusing the
Own son. That it has done by the Adilur, who has transferred the shares. Now, how can there be a different interpretation? In which document we don't know, but it is done by the Adilur itself at his lifetime. That is his case. Their case itself, my lord. I'm not saying I'm not interpreting my case, my lord. Their own case is that the Adilur did transfer the shares.
And when the complaint may be quashed, under what circumstances?
My lord, when there is a doubt, my lord,
Not doubt.
the prima facie, there has to be some prima facie case, my lord.
If there is no material.
No material. So first of that, if there is a material, first of all, there has to be a document, first of all, where forgery been committed. First document is. Secondly, if there is a document, who committed the forgery and how he committed the forgery.
That acquisition is necessary.
Acquisition is against the own son, that he did the forgery or the why he did the transfer. Maybe legal, maybe illegal, maybe by forging. We don't know.
And as regards section 420,
420, my lord, where is my initial dishonesty, my lord? From inception, I must have the dishonest inception from the very beginning. That is the 415. So I must represent something which is false. And by virtue of my false representation, false statement, this property must be transferred. Some benefit. I must acquire some benefit on false premises, dishonesty. Where is 420, my lord? There is no deception, my lord, on my part.
okay.
There is no allegation also that I have stated something else. I have falsely implicated or falsely stated some statement made by. So, forgery, 420 is a far beyond my consideration. There has to be initial deception on my part. I have to make some false promise or something, inducement. I have to induce. Where is my inducement to the complainant? My husband might have transferred the share, and their own statement that it was my husband who transferred it during his lifetime. He was the MD. That's my case, man. That's all, man.
Now, Mr. A.M. Bora, Learned Senior Counsel for the Learned Senior Counsel assisted by Mr. A. Bora, Learned Counsel for the petitioners. Also heard Mr. N. Das, Learned Counsel for the respondents. The hearing is concluded, judgment reserved.
Obliged. I have realized some judgment already, maybe the part of the. Realized some of the document regarding the. Okay. So obliged.
Into Bitarod Diba. We don't have time. 13 and 14 ready for hearing.
So the other side is not present, my lord. Any day may be fixed, my lord.
Your appellant
Appellant.
heard Mr.
Yes, Bhattacharya.
Mr.
Yes.
What is your name?
Yes, Bhattacharya.
P.S. Bhattacharya, Learned Counsel,
CGC.
Learned
CGC. my lord.
Central Government Council. Appearing for the appellant. None appears for the respondent side. Let this matter be listed after 2 weeks. 2 weeks.
Diplomat.
Not the other side. He was there, but he went to some other court, I guess. My lord, may you kindly fix a date if possible.
No, date may not be possible.
My lord,
Date may not be possible. When do you want it?
my
Yes.
lord, he said.
My lord.
Now time is not available.
Yes.
6th of August.
6.
What is the matter?
Matter is.
2017. testamentary.
Application for letter of admission was dismissed. Application for letter of dismissed. And this is the appeal.
Okay, when do you want?
Six
Sixth
August.
August. Heard Mr. P. Upadhyay, Mr. A. Upadhyay, learned counsel for the appellant, learned counsel for the petitioner. Is it a learned counsel for the appellant? Is it an appeal?
Yes. Title suit, employer title suit was dismissed, my lord.
Then you came on
Appeal.
under what provision?
Provision, my lord, yeah.
Learned counsel for the appellant. Also heard Miss
J. Sharma.
J. Sharma, learned counsel for the respondent. Due to paucity of time, this matter could not be heard today. Let this matter be listed again on 6th of August for hearing.
Obligement.
Obliged.
Number 17, item number 17.
16. Okay.
No, I'm for the appeal.
I'm for the respondent.
Then I need it. Sir.
After 2 weeks, wait, after two weeks,
August now.
after 4 weeks. This matter could not be taken, heard Mr.
P. Bora.
P. Bora, learned counsel for the appellant. Also heard Mr.
S.A. Bhakhtiar.
S.A.
Bhakhtiar.
Matia, learned
Bhakhtiar.
B.H.A.
B.A.K.H.
Bakia.
Bhakhtiar.
PIA.
On behalf of N. Alam.
What is the spelling? B?
AQ. PIA.
B.A.K.H.T.I.A.R.
B.A.K.
H.T.I.A.R. I will write.
Bhatia.
Bhakhtiar.
Bakhtiar.
Yes.
Okay. You are not pronouncing it properly.
My apologies.
Mr. Bakhtiar, learned counsel for the respondent. Due to paucity of time, this matter could not be heard. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Item 18 and 19.
Obliged.
Lordship, this matter, it has an interim from since the year 2019 by the virtue of a fraudulent document, they're enjoying this interim. It had come up before this, that's why I pray Lordship, this matter be listed on 30th. Well, there's a consent of in item number 19, the junior counsel was here whole day, but now I don't see her. According to her, she gave me the date that her senior is available on 30th. So Lordship, I pray urgently to list on 30th, Lordship.
This is a say. Many cases are there.
No, Lordship, only 2 cases. There are some miscellaneous applications, but though against the fraudulent document, there is some prayer for punishment. That is, those are the miscellaneous application.
You are for?
I'm for Adda. In both of them, I have come here to vacate the interim order.
For respondent number 2.
2. 1 in 2. I'm for Assam Drug Dealer Association, Lordship. In 41, I am respondent number 1. Here also same thing, respondent number 1 for both the cases.
Yes, what your name is? S.
As
Parveen.
Parveen.
Heard Miss S. Parveen, learned counsel for the respondent. None has appeared for the appellant side. Learned counsel for the respondent has submitted that she has taken consent from the counsel for the appellant for fixing this matter on 37/2024, considering the urgency of the matter. Stop. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed on 37/2020.
Lordship, instead of consent, they have consented to 30. That's because if your lordship sees the file, in and out, they keep on taking time. That is why, because I always ask, what is your convenience?
Okay. Matter, things remain same.
Highly obliged.
May please, your Lordship. Lordship, my humble preference, a date may fix, Lordship. It's of urgency on my part, Lordship, because the claimant is, husband is suffering from some disease and some urgency is there, Lordship.
Who is for the respondent? You are for the?
I'm for the respondent number 1, Lordship.
Okay. Whose appeal? Insurance company's appeal.
Insurance company, only.
Learned counsel for the appellant is not found on call. Heard Mr.
S.N. Krishnatra.
S.M. Krishnatre. Learned counsel for respondent number
1.
1. Who prays for early listing of this matter as the claimant respondent has been deprived of the fruits of the award due to the interim stay. Stays there.
Yes, Lord.
Stay granted in this case. Considering the submissions,
Lordship, can it be on 1st or 8th of August, Lordship?
let this matter be listed on 8th of August.
Deeply obliged.
Remaining matters left over, registry will fix dates.
Item 26, Lordship.
We don't have time.
Title execution, Lordship, this matter. Since
11
11 it has not been.
Mention time, so matter we fix any date after next week.
Any date at your
Item
Lordship
number?
convenience.
26.
What is your prayer?
Fix another day, Lordship. My senior is out of station.
Fix the date, Lordship, at your convenience.
Item number 26. Learned counsel for both the sides are, both sides are there.
Yes, yes, sir.
Both sides are represented. Due to paucity of time, the matter could not be taken up today. Let this matter be listed again on,
Interim is there, interim.
let this matter be listed again on 8th of August 2024. The interim order shall continue till next year.
Much obliged.
Item number 25, I am for the respondent side, Lordship. There is some urgency. Date may be kindly fixed, Lordship.
When do you want?
Lordship,
When do you want it?
13th,
Other
Lordship.
side is there. Both sides are there.
Lordship.
When would be convenient for?
On 13th, Lordship, or 6th,
No, not on 30th.
then on 6th,
6th
Lordship.
of August.
Lordship,
Lordship, can it be on 8th, Lordship?
Okay.
not on. Lordship, there is some difficulty on part of my senior Lordship.
Heard. What are your names?
P. Bordle, Lordship.
Heard Mr. P. Bordole, learned counsel for
Lordship, appellant, Lordship.
appellant, as well as Miss
P. Sharma,
P.
Lordship.
Sharma, learned counsel for the respondent. This matter could not be heard due to paucity of time. Let the matter be listed again on 6th of August.
Much obliged.
My lord, item number 27, my lord, there is an interim, it should be continued. Here stay matter, my lord, respondent number 1, this notice was said but service not completed. Alternative address is available in the records, my lord. So we actually pray for liberty to send notice in alternative address, my and Kolkata.
Item number?
Item number 27.
Item number 27. Heard Mr.
M.J. Burwa.
M.J. Burwa, learned counsel for the petitioner, who submits that the notice issued to
Respondent number 1.
respondent number 1 has not been served.
Yes, return.
However, alternative address of the respondent number 1 is available in the record.
Yes.
And he prays that the petitioner may be allowed to take steps for issuance of notice on respondent number 1 in the alternative address which is available. The prayer is allowed. The petitioner shall take steps by registered post with AD as well as through usual mode for service of notice on respondent number 1 at his alternative address. Let this case, the notices shall be returnable on 29th August, list according.
Interim.
The interim shall continue.
Nice. God bless you.